Good morning, everyone. Welcome to today's hearing. Today we're going to hear further closing statements in relation to modules 1 and 2 from various core participants. The first statement we're going to hear will be made by Mr. Michael Douglas, Queen's Counsel, on behalf of Exova. And I'm now going to check that Mr. Douglas can see and hear us and we've got proper communication. Good morning, Mr. Douglas.
Good morning, Mr. Chairman. I can hear you and see you.
Good, thank you very much. And we can see and hear you. So you're going to make a statement on behalf of Exova, is that right?
That's correct.
And if you're ready, then we're ready to hear you. Thank you very much.
Thank you. Well, again, good morning, Mr. Chairman, and good morning, Ms. Istefan and Mr. Akbor. The panel already has Exova's submissions in writing. Those submissions are detailed, fully referenced, and they stand in full. My purpose today is to develop 4 aspects of our analysis. We will first address Exova's position in the project, and with particular reference to the facade. We will then deal with Dr. Lane's written evidence, tying Exova to the cladding system, and the rowing back from her position as evidenced in the later iterations of her report and in her oral evidence. We want to look at the specific questions that arose in relation to cavity barriers. And we will also touch on some areas that have been the subject of some debate: the impact of Ryden's appointment, the existing fire strategy report, duties under the RRO, duties in connection with Regulation F38 and means of escape, and talk about what they actually amount to. We will also deal with causation and 1 or 2 confined issues that need highlighting. We will also deal, but only insofar as it is necessary or appropriate to do so, with what other participants have said in their written closing submissions. There are a great many of the points made there are in fact already addressed in our own written submissions. So in that respect, we will be relatively short. So starting with Exova's place in the project, through the TMO, which in turn was agent for RBKC, it appointed Exova. It did so at Studio E's recommendation in order for Exova to provide input to Studio E. It was thus with Studio E, and on occasion Max Fordham, that Exova communicated, and at Studio E's behest, that Exova was included or not in communications with other team members. So, for example, Exova attended 3 design team meetings between September and 31st October 2012, but was not invited to the design team meeting later in November, or to any of the 7 design team meetings in 2013. Mr. Ashton accompanied Studio E to a meeting with Building Control in November 2012 concerning risers, access by fire services, the new lower level, and means of escape. And he again accompanied Studio E and Max Fordham to 1 further meeting with Building Control in September 2013, which concerned layouts on the lower floors and smoke ventilation. He had a number of discussions with Mr. Soons in that month, and again into November 2013, again primarily in relation to lower floor layouts, staircase access, and smoke ventilation issues. Those conversations led to issues 2 and 3 of his report, and also his offering that colleagues would carry out a computational fluid dynamics study for the new smoke control system, though in the event, KCTMO Max Fordham chose to go down a different route. That aside, Exova were not invited to any other meetings before Ryden were appointed at the end of March 2014, nor to any that took place after Ryden were appointed. These points are not disputed. I repeat, the only meetings that Exova attended or to which they were invited between the end of Stage C on the 31st of October 2012 and the end of the project in July 2016 were 2 meetings with Building Control in November 12 and September 13. That, objectively, is a very striking fact. Whilst the appointment of Ryden as D&B contractors was an important event in the history of the project, the facts just referred to show that, in truth, throughout the project, even prior to Ryden's appointment, Exova were not actively involved by the design team, and indeed mostly left to one side in the project development of the facade. So far, I have referred to meetings, but the same theme holds true of critical information and design documents. They were simply not communicated to Exova, who were ignored. For example, in the summer and autumn of 2012, Studio E had detailed discussions with Max Forden in connection with thermal insulation performance and choice of insulating materials. But even though they were discussing other fire strategy issues with Exova at around the same time, they sought no input on fire issues in relation to the facade. Through much of 2013, cladding materials were discussed between KCTMO, Studio E, Artelia, Leadbitter, CEP, and subsequently Harley. The contents of those discussions were never communicated to Exova, nor even the fact that those discussions were taking place. Specifications for the proposed cladding system, with details of the proposed materials and provisions with respect to compliance, including fire compliance, were set out in the crucial NBS documents. These were compiled entirely by Studio E, who never sought Exova's input. Exova never received a copy, whether in draft or final form. Likewise, no part of the employer's requirements for the tender of the D&B contract was ever communicated to Exova, nor were any details of the tender responses provided for evaluation or comment, even though Exova's own fee proposal had offered to assist in dealing with issues that appeared during the tender review process. Exova, in other words, was left out of the entire tender process, and throughout that period were asked only one isolated query by Mr. Reck, which I'll touch on later. Then there is the crucial decision to change the cladding materials to incorporate Rainabond PE 55 ACM rain screen panels and Celotex RS 5000. That decision, made between Ryden, KCTMO, Studio E and Harley, was not communicated to Exova, much less were they consulted on these matters, nor for that matter, the later decision by Ryden and Harley to include Kingspan K15 in addition to or in substitution for Celotex RS 5000. This is quite contrary to what has been suggested yesterday, that Exova was appointed with full knowledge of the materials. In parallel was the process of the full plans application for building regulation approval, followed by the S1 and S2 applications, all made by Ryden through Studio E without Exova being invited or expected to play any part. Indeed, there were numerous occasions over the course of 2015 to 2016 where the TMO consulted Ryden and Ryden consulted RBKC and other parties on fire-related matters. Exova were neither included in nor consulted about these meetings, as Barbara Lane now catalogues in her fire engineering report at paragraphs 11.279 to 11.291. Again, these points are undisputed, and again, they are very striking. This was supposed to be a coordinated design team. Pre-tender, TMO assigned that responsibility of coordination to Studio E as lead consultant. Studio E needed, therefore, to consider what specialist and what they needed, particularly given the gaps in their own experience, and to instruct their specialist consultants accordingly. Later, Ryden had overall responsibility for coordinating the project and used Studio E to coordinate the application for building regulation approval. Again, the position is compounded, worsened after Ryden's appointment, because, notwithstanding their duty to procure all the relevant forms of specialist expertise, their lack of any specialist expertise themselves, the obvious need as a result to have somewhere in the post-contract team to which every one of the specialist responsibilities could be properly and clearly allocated, their obligation to complete the work in progress that comprised the employer's requirements, including, under their contract, the advice given up to that point by Exova, Ryden consciously and deliberately decided not to appoint Exova, or for that matter any other fire consultant, as part of the design team, but instead, as confirmed to Mr. Soons in or about March 2014, to rely on the architect, specialist cladding contractor and building control to secure compliance with the building regulations. This was despite 6 attempts post their appointment to persuade Ryden to use Exova or a fire consultant. It was no longer possible from March 2014 onwards for Exova's formal engagement to continue as it had been. They ceased thereafter to be or to be thought of as part of the Grenfell Tower project team, and no attempt was ever made to integrate Exova into that team or the development of the project. And it is worsened yet further by the fact, at least so far as the facade is concerned, The whole question of regulatory compliance seems to have fallen between the cracks. At an organisational level, Ryden failed to ensure that a design responsibility matrix was established and maintained to provide the required certainty of responsibility for the remaining design and build activities and highlight any gaps. Notionally, Studio E accepted contractual responsibility for compliance, but they did so retroactively, near the end of the project, having hitherto apparently believed that their responsibility was only to check the contractor's designs by reference to conformity with architectural intent. The oral evidence showed that every one of the participants in the facade package believed that responsibility for compliance did not rest with them. So I turn then to Dr. Lane's evidence. We have in our written submissions made a number of criticisms of Dr. Lane's evidence. I will for the most part not repeat them now, though we firmly maintain them for the reasons we've set out. What I seek to do here is to develop certain important points on Dr. Lane's criticisms and conclusions. The three versions of Dr. Lane's report each have over 300 pages of minute analysis and critical statements. I'm going to focus on three highly significant paragraphs which were introduced in the second version. The first two are as follows, and I'm using the final version as the reference point. Paragraph 9.1.34. It is very important to acknowledge the change from zinc to ACM, and it is correct that Exova were not asked for their opinion about this change as I read the evidence available. 9.1.41. I can understand why, before 18th September 2014, it could be said that Exova may not have read or proactively sought relevant information about the external wall build-up upon which to base their fire strategy, albeit I do not consider that it was reasonable for Exova not to have taken steps to understand that before then. I'll come back to that comment at the end about what Dr. Lane believes should have been done. She said more about that in her oral evidence. But from the rest of those two paragraphs, we take these points. First, the decision to change materials from compliant zinc honeycomb rain screen cladding, see Lane 9.1.37, to the ACM, which was the critical reason for the spread of the fire, was in itself and obviously a very important step in the exterior cladding at Grenfell Tower. So too was the fact that that decision was undertaken without any reference to Exova or any other fire consultant. Conversely, it is professionally understandable why, at least up to 18th September 2014, Exova was not aware of it, had not read about and did not proactively seek information about the proposed build-up of the external wall. This is a crucial issue, and these are crucial concessions. This was a cladding fire. It happened because of the choice of materials, and what Dr. Lane concedes from her version 2 onwards is that Exova A were not aware of the choice of rain screen, and B, as we shall demonstrate from her oral evidence very shortly, were not obliged at the time it was chosen to look into the choice of insulation. That brings me to the third paragraph, which is this, 9.1.42. But it is clear that on 18th September 2014, the Celotex data sheet was sent to Terry Ashton, and he responded to that email. Now that is expressed in a very guarded and selective way. It is an example, one could say, of seeking to wound but fearing to strike, implying without actually saying so, one, that Exova knew that the insulation was Celotex when that is not the case, and two, that Mr. Ashton responded to or commented on the data sheet, which he didn't. I'll come back to those points later. But what matters for present purposes is that it illustrates Dr. Lane's focus from her second version onwards on ACM, not on ACM, forgive me, but on Celotex as the main basis for criticism of Exova. This is confirmed in Dr. Lane's comments on Mr. Ashton's responses to questions asked of him after Ryan's appointment, and her conclusions, both of which I deal with separately later. It is also necessary at this point to refer to Dr. Lane's oral evidence at days 61 and 62 to examine what her, I will call, up-to-date evidence is on the actions of a reasonably competent fire engineer in the period 2012 to 2015. First, the stage, following on from Dr. Lane's evidence, But contrary to what Studio E expected, Exova ought to have analysed the information in the Stage C report. Her evidence in the witness box was nevertheless much more limited. She says this: I think the minimum I would expect a fire engineer in that year, that was 2012, to notice was some type of surface, some type of insulation being applied on every story, and nothing further. The minimum would have been the building is being overclad on every story. Some materials are fixed, some materials are not yet fixed. Here are the performances as a minimum. Before the Grenfell fire, no, I would not have expected them to take any further step regarding satisfying themselves about products. I want to be absolutely clear on that. Secondly, reference was made to the course of action that should have been taken in the absence of much information having been made available to Exova. That, Dr. Lane said, was to set out as an absolute bare minimum the statutory guidance for insulation cavity barriers in the external surface. If you're given no drawings whatsoever about the overcladding, and that has happened many times, the best thing left for you to do professionally is to simply state the statutory guidance minimum requirements. Thirdly, and in the same vein, how issue 2 of Exova's report in October 2013 should have addressed B4 if they still felt they had limited information as to the proposed changes to the exterior. Which refers to section 12 regarding the construction of the external wall, bare minimum, writing down the minimum performance requirements for each of the layers. So that's the bare minimum, not bringing in any post-Grenfell levels of detail. Then, as to what should have been done in relation to materials, 3 points. Question: would you expect any kind of analysis of materials at this stage? Answer: we're in 2013 now. I'm not going to say that they should automatically have read up about Celotex, because I know that wasn't very common practice at the time, okay? That's why I'm just keeping on saying writing down the recommendation or the requirements in approved document B is the bare minimum. So just that statement is the minimum piece of professional guidance I would have written down in the FAR strategy. And if one had noticed Celotex in the Stage C report, it would have been an extra step at that time to explore what that meant. Some professionals would have done, some professionals would not. And in answer to a question from the chairman, Dr. Lane confirmed that she meant by her expression, some reasonably competent professionals. Later, she said that 2013, 14 and 15 was a very complex time. And that finally, I'm still not going to say the bare minimum for Mr. Ashton was to take out the Celotex brochure or get some reports. I'm still not going to say that at this moment in time. While Dr. Lane gives the example of Celotex, her evidence is in relation to materials or products generally, and therefore applies just as much to Rainabond ACM. There are other examples of Dr. Lane accepting that fire engineers did not need, nor was it their normal practice, to deal with materials. Version 1 of her report at page 251 makes the statement. In line with that, importantly, nowhere in her reports or her oral evidence does Dr. Lane explicitly or even implicitly criticise Mr. Ashton for not having noted or advised on the proposed use of ACM. I've already referred to her statement that it's very important to note that they were not consulted about the ACM change. Then Zinc Proteus HR on its own was class 0, hence complied with diagram 40 of ADB 2013 for use in a building above 18 metres in height, paragraph 9.1.37. I don't want to say that I would immediately have expected Terry Ashton to have noticed aluminium and to have done something else that day. The fact that they're referring to an email in a chain relating to the 31st of March advice mentioning ACM cassettes. Forgive me, aluminium cassettes. These comments reveal an important limitation on Dr. Lane's views. She's not saying that a reasonably competent fire engineer ought to have made inquiries as to the material being used, nor even that had Exova seen products and materials actually mentioned in a design or specification, they should have investigated them and expressed an opinion on whether or not they were compliant. Rather, the supposed obligation of the reasonable professional was simply to have set out or written down the recommendations or requirements of ADB2, or the performance requirements, or even just the outline performance requirements. Writing down, whether it means setting out the relevant provisions of ADB2, or referring to them, or identifying the relevant paragraphs, in itself seems a surprisingly basic task, and one which has little utility until it can be coupled with practical advice in connection with the particular proposed materials. Indeed, until that point, it risks being positively unhelpful, given the acknowledged ambiguities of ADB2 and its diagrams 40 and 33. That is something that the fire engineer can only do once they're given materials to comment on. Dr. Lane accepts that Mr. Ashton was under no obligation to investigate, inquire, and pursue that point. In any case, this supposed duty to write down the performance requirements runs up against the expert evidence in relation to the professionals who would receive that advice. Mr. Hyatt is entirely clear that an architect had no need for such advice. In Mr. Hyatt's words, it was, a specialist fire engineer should not normally be required to assist an architect in interpreting and applying the guidance of ADB2 with respect to specifying the materials within and designing the arrangements for an external wall or overcladding system as applied in an external wall. Entirely clear, we say, and we also say clearly right. That is in contrast with Dr. Lane's oral evidence, which was notably variable and indeed unsure about when the practice of checking materials developed into a professional practice or even duty. Was it 2013, 2014, 2015, or after Grenfell? That confusion makes it very difficult to be sure of the ground on which rests the alleged criticism for supposed omissions on any of the particular occasions, the opportunities which as Dr. Lane refers to them in paragraph 9.1.25. And there's another point, because you'll remember I said that I would return to Dr. Lane's statement about that her view that notwithstanding that she could understand the point, she thought that it was unreasonable for Exova to have taken so long. I would say that the practice that she describes and the duties which she describes demonstrate entirely why it would be understandable by a professional body of opinion they hadn't investigated proactively the materials or read up about them. Entirely explicable. Her point of view, on the other hand, also her view that it was unreasonable for them not to have, seems to me to be inconsistent with the evidence she's actually given orally about what the practice was. Despite accepting that Mr. Ashton was not aware of the proposed use of ACM, nor obliged to make inquiry about ACM or Celotex, nor obliged at that stage to comment on the proposed choice of materials generally, the view in Dr. Lane's report in its second and third versions is, first, that the use of Celotex nullified the compliance of the external wall assembly because it was not a product of limited combustibility. And secondly, that therefore, regardless of the surface material, paragraph 3.1.4 of Exova's fire strategy, no adverse effect, was quite simply always wrong. That statement is not correct for two reasons. First, it ignores, and not for the only time, the express reservation which follows the partial quote. The proposals provided to Mr. Ashton on which he was asked to base his report did not yet include anything that had an adverse effect on external fire spread. The position, as he said, needed to be confirmed in a later report. Secondly, since, as Dr. Lane expressly accepts, professional practice did not require Mr. Ashton to check materials at that stage, it was not wrong at that stage to give that opinion subject to those qualified terms so that it could be revisited and confirmed later as appropriate. I've already mentioned that as a result of the limited view Dr. Lane takes of the fire engineer's duties, she nowhere criticised Exova for a failure to comment on the rain screen panels. The closest Dr. Lane comes to criticising Exova for not commenting on the suitability of the particular materials is on the basis of her implying that Mr. Ashton knew the product was Celotex because he was sent a data sheet identifying it. That is wrong, both factually and conceptually, as we explain when we visit in more detail the email exchanges of the 18th of September 2014. Turning to first principle, we seem to arrive at the point where Dr. Lane's entire case appears to be that Exova failed to set out or write down the provisions of ADB, paragraphs 12.5 to 12.9. Aside from whether that really ought to have been a task for a fire consultant advising an architect, and the expert architect says not, as already quoted, one has to ask what difference it would have made. There are problems with ADB too, including diagrams 40 and 33 and their annotations, which merely citing it will not cure. The manufacturer's claims, as we know, are calculated precisely to deceive people into believing that their products did indeed comply with those requirements. In any case, the die was cast. The materials were selected for cost reasons without compliance ever being meaningfully considered by any of those who made and implemented and oversaw those selections. Even before the contract was let, there had been a steady and increasing pressure to use cheaper alternatives to zinc, notably ACM, in order to meet KCTMO's budgetary challenges. It started in early 2003 with the commencement of a period of value engineering initiated by Leadbitter. In or about March 2003, Mr. Soons met CEP and discussed ACM. In April, Harley came on the scene and in September 2003 had a meeting with Studio E at the Hayes Galleria, at which Harley began to mention ACM, relying in part on their having used it in so many other projects. In October, Harley provided Studio E with a budget spreadsheet and followed that up by a further spreadsheet indicating that the choice of Rainabond could save up to £500,000. Harley further stated that from a Harley selfish point of view, they would prefer to use ACM. KCTMO became involved in the specification, and Mr. Madison wanted ACM alternatives to be included in the NBS, which they were. Harley had worked with Ryden on high-rise projects, in particular the Chalcott estate, at which ACM was used. Ryden then used Harley to assist in their tender submission by the provision of figures, and again for their secret negotiation with KCTMO to reduce the tender price. By 31st March 2014, it was a foregone conclusion that the cladding would be ACM, motivated by cost and nothing else. Ryden then assisted in presentations to RBKC planning supporting the change to ACM. Harley were persuaded directly by Celotex to use Celotex RS5000 insulation. Studio E, KCTMO, Ryden, Harley all approved the use of these materials in the summer of 2014. Studio E seemed to have gone along with the proposal and approved the final cladding design without getting to grips with the issue or seeking any independent advice about the suitability of the proposed materials. Not once over the 20 months period of this groundswell in favour of using ACM, not once did they ever inform Exova about the proposal and actual selection of materials. In November 2013, the structural engineers, Curtins, provided to Artelia and Studio E a structural specification for the exterior works. It listed regulations and guidance applying to all aspects of the work. It included in that list a recommendation to follow BRE 135. Clearly, the design produced for Grenfell Tower did not follow that advice. That provides material evidence of the fact that even if advice had been given, citing regulations or sections of ADB, it is far from a probability that such advice would have been followed, or even, given ADB's confusions, that it would have been understood. We know, moreover, that there continued to be scant regard for post-contract compliance, even though the facade section of the NBS required not only compliance, but documentary evidence of compliance. No such evidence was ever requested or provided. I then turn to the individual questions put to Exova in relation to cavity barriers on 3 occasions. Pre-contract. I mentioned earlier that during the pre-contract period, Exova was asked only once about anything to do with cladding. That was on the 4th of November 2013, when Mr. Reck inquired, can you please confirm that the rain screen cavity barriers are to be 60 minutes fire resistance to match the compartation? This was a single and very narrow request, to which Mr. Ashton replied, Thomas, cavity barriers need only have a 30-minute fire resistance. That was the sum total of the interaction. The answer was correct, and it is also the case that the standard for cavity barriers under ADB2 is uniform. See Appendix 1, line 15. In her report at page 277, Dr. Lane made some semantic criticisms, but in oral evidence accepted that Mr. Ashton had said the minimum that he could have said. We then need to look at the post-Ryden appointment ad hoc questions. There are then two queries, a few months apart, raised ad hoc during the Ryden period, both on equally narrow points. 18th of September 2014. On the 17th of September 2014, Mr. Anketel-Jones of Harley emailed Studio E, Mr. Crawford, with a request for information concerning the location of fire breaks at compartment floor level. We believe that they, he said, horizontal fire breaks, will be required at every floor level on the vertical columns, but not in the area of cladding between windows. This is because there is no chimney effect here. It's difficult to resist the inference that this was a cost-saving issue for Harley. However that may be, the question was a narrow one. It was not a broad-ranging issue about cavity barrier design or performance, but a simple, do we need to put horizontal cavity barriers at the floor level between the spandrels? The history is then this. Mr. Crawford forwarded the RFI to Mr. Ashton on the 18th, asked the question to Mr. Ashton, do you believe the interpretation to be correct? Mr. Ashton responded, saying correctly, I've never seen details of what you're doing to the external walls. Do you have any cross-sections or elevations? Mr. Crawford replied, forwarding Harley drawings, which he said are fairly limited. On those drawings, insulation is depicted, but not identified. Mr. Ashton responded, if the insulation is combustible, you will need to provide a cavity barrier in order to prevent fire from spreading from one flat to the one above. And that reply was then sent back to Mr. Anketel-Jones. Now, at this point, we accept that there's scope for criticism. At the time, insulation could be combustible, provided it was classed as limited combustibility. But more to the point, the cavity barriers were necessary in any event. The exchange continued. Mr. Anketel-Jones responded to Mr. Crawford, Dear Neil, thank you for your response. The insulation is class 0, therefore, after reading the correspondence below, I believe that the fire barrier in these locations will not be necessary. Can you confirm that this is acceptable? That email was forwarded to Mr. Ashton. Mr. Crawford asked, Terry, is this interpretation correct? See below, that was Mr. Anketel-Jones' email. Mr. Ashton, in response, made 2 points. Firstly, he said that class 0 is not necessarily non-combustible. Secondly, that, in any case, you need to prevent fire spread from one flat to the one above, as I stated in my earlier email. So Mr. Ashton ended up, admittedly by an erratic route, in the right place. He did not give a textbook answer. There was a slip in his working, but the answer he gave to the question he was asked is the right one. Contrary to Harley's suggestion, cavity barriers were indeed needed. Now, Dr. Lane tries to take an entirely separate point from this exchange and to elevate the 18th of September 2014 on the basis of this narrow query into a date of central importance. What nobody mentioned at the time was that Mr. Anketel-Jones' email to Mr. Crawford, in which he described the insulation as class 0 and argued that this meant there was no need for a cavity barrier, had a document attached to it. Mr. Crawford does not recollect reviewing the attachment, and it is open to doubt that he even noticed it at the time. The contents of the attachment related to Celotex insulation, though that was not mentioned in or apparent from any of the emails in the chain, nor from the name of the attachment. Neither Mr. Anketel-Jones nor Mr. Crawford referred to an attachment, or asked about it, or made any mention of Celotex. Mr. Anketel-Jones made a general proposition. Mr. Crawford asked if it was correct, and Mr. Ashton correctly said that it was not. He had no need to open any attachment, nor even to note that there was one. His answer did not depend on the contents, but only on the question. It is clear, though, that Dr. Lane now regards now relies upon this interchange as the main thrust of her criticism of Exova's conduct in connection with the external cladding. This can be seen in several quotations from her report. 9.1.26. The evidence that Terry Ashton was sent the Celotex RS 5000 datasheet is particularly relevant. 9.1.38. The fact that Celotex RS 5000 was not a material of limited combustibility nullified the compliance of the external wall assembly. Therefore, regardless of the surface material, section 3.1.4 will have no adverse effect statement was quite simply always incorrect. 9.1.42. But it is clear that on 18 September 2014, the Celotex data sheet was sent to Terry Ashton, and he responded to that email. 9.1.43. Therefore, Exova's reports and their email guidance fundamentally failed to consider the implications of the cladding design on the life safety of occupants of Grenfell Tower. 14.1.46. Even when, on 18 September 2014, Terry Ashton was directly asked to comment on concerns about cavity performance and was sent drawings, he failed to communicate correctly the performance required necessary to satisfy B41. I note that Mr. Ashton was specifically sent a data 14.1.48. I note that Mr. Ashton was specifically sent a datasheet of the Celotex RS 5000 insulation by email, which stated that it only related to the comments detailed and that any changes would need to be considered by the building designer, a caveat that Mr. Ashton did not raise with the design team. 14.1.62, 18th September was a point in time when a detailed fire strategy, which Exova had themselves proposed, was needed and could have been successfully put together by them. But this is layer upon layer built on a slender foundation. Mr. Ashton was not specifically sent a data sheet. It happened to be silently attached, and he was never asked about it. Certainly he responded to an email, but the question he answered was nothing to do with Celotex or the datasheet, and so neither was his answer. The question was not a concern about cavity barrier performance, but simply a query about the need for cavity barriers in a particular location. His answer was not a fundamental failure to consider life safety. It was a correct response to the questions that he had been specifically asked. Since there was no need for Mr. Ashton to read the unmentioned attachment, still less can he have been under a duty to flag up the caveats within it, which in any case were beyond the scope of the question he was being asked. The implication in almost all of the passages just quoted from Dr. Lane's report is that Mr. Ashton knew that the product was Celotex and is a leap without foundation in the evidence, starting with what I described as the seeking to wound but fearing to strike. Nowhere, even in any of these many quotes, does she actually say that Mr. Ashton read the attachment, or even actually expressly that he should have. On 18th September, Mr. Ashton was proposed a narrow ad hoc question to which Studio E wanted an answer. He was not then or at any point thereafter asked for or expected by anyone to produce a further iteration of the fire strategy report, nor was he given comprehensive up-to-date material on the project as a whole, which he would have needed for a further full report. The limited intervention was all that was requested and all that he held himself out as providing. We then go to the 31st of March of 2015. In late March 2015, a dispute developed between Harley, Ryden and Siderise on the one side and building control on the other side as to whether at compartment floor level, ADB2 required the gap between the compartment floor and the external cladding to be fire stopped for 120 minutes, or whether the detail was a cavity barrier, 30 minutes integrity and 15 minutes insulation. Siderise had advised that the cavity barrier argument was correct. Mr. Hoban of RBKC had, however, concluded that fire stopping was necessary because the detail, as he said, between the compartment floor and the existing cladding was not a cavity barrier. On 31st March 2015, Mr. Crawford, shortly after strongly siding with Harley and Ryden's argument, asked Mr. Ashton to comment on the dispute. In describing this situation, Dr. Lane said at day 62, "We now see entering the narrative here a confusion about the difference between a fire stop and a cavity barrier, and we see someone who understands that fully, and we need someone here who understands that fully, and the primary issue here is a lack of understanding about the difference between a fire stop and a cavity barrier. But again, this is wrong. There was no confusion on the part of the Ryden design team, who all correctly believed and had argued that the detail at compartment floor level was a cavity barrier, not a fire stop. The question was narrow and purely binary. Either the requirement is for a fire stop or it is for a cavity barrier. The design team all thought it was for a cavity barrier. Mr. Ashton swiftly agreed with them. He was right. Mr. Hoban retracted his previous opinion the next day. He did so probably on the basis of Mr. Crawford's email. There's no evidence that Mr. Ashton's note was ever forwarded to him. No broader issue arose on the emails, and no drawings accompanied the queries to draw attention to a wider issue. Accepting that Mr. Ashton's answer was correct, Dr. Lane nevertheless criticised him on two other bases. First, Mr. Ashton's comment that zinc cladding would fail in external flaming. But again, it is correct as a statement of fact that the zinc panel would deform and potentially detach in that scenario. Indeed, Mr. Ashton's view was confirmed separately by Mr. Pearson, who explained in his oral evidence that this was a known and accepted risk with individual panels. This evidence was given at day 19, page 178 to page 181. His evidence on that issue has not been challenged. Secondly, Mr. Ashton's comment in passing that this was not something that would necessarily form part of the strategy, Dr. Lane says, was entirely wrong advice to give at that time and remains so. In his oral evidence, Mr. Ashton accepted that he was wrong in the way he had expressed it and explained how he was dealing with a slightly different point, meaning simply that a fire strategy would not normally include a detailed commentary on whether ADB required cavity barriers or fire stops in this location. In any event, he answered the question that was asked, and Dr. Lane's report acknowledges that he answered it correctly, so nothing at all turns on that comment. I now raise a separate issue about cavity barriers, which has emerged in the course of Module 2, and that is the question of the efficacy of cavity barriers generally in rain screen cladding. It has nowhere been suggested that Studio E or Harley were wrong to include cavity barriers in the design of the building at all, or that Exova were wrong to advise that they should be included, or that cavity barriers actually installed were not compliant with ADB, though many were poorly installed, and there were gaps as to where they should have been inserted. Rather, the complaint against Exova is that they did not, when considering the ad hoc cladding questions in September 2014 and March 2015, point out that cavity barriers were required around the windows. Whether they should have done so is, of course, bound up with Exova's responses to the questions asked, which we've already dealt with. Over and above that, though, there is a particular causation which it is important to note. On any view, Exova were not responsible for designing the windows, their shape, size, or location. Had Exova advised in broad terms on the requirements of ADB2, it would not have needed to be much more extensive than confirming that openings, including windows, were to be required to be closed by cavity barriers with 30 minutes fire resistance and 15 minutes insulation. Had they been asked to review a plan drawn up by Harley or Studio E, it would have been sufficient to have an indication, e.g. a thick or dotted line, or a yellow circumference around the windows as shown on Mr. Hyatt's diagram at page 44 of his main report, figure 3.16, that would have demonstrated the intended compliance with ADB2 diagram 33. As Dr. Lane herself acknowledges, detailed drawings and specifications are for others, not the fire engineer. And while a fire engineer formulates a package of protection measures, many other parties then take on the responsibility of the detailing of any active and passive protection measures required, the construction of those measures, and so the quality of what is ultimately built. In other words, any elaboration of the design would be for others once the intention to provide cavity barriers was adequately demonstrated. But the even broader question is whether, given the actual complexity of the construction arrangements, it would even have been possible to design a cavity barrier system that would have been effective. At the very least, it would have been exceptionally challenging. In phase one, Professor Bisbee and Dr. Lane concurred that the particular conditions at Grenfell rendered that almost impossible. Professor Bisbee said, "To be honest, and I've thought about this, I'm not sure how one would put a cavity barrier around walls installed in this manner. It's an almost impossible question to answer because I can't imagine how one would actually achieve what one is attempting to achieve by putting a cavity barrier around the window." Dr. Lane echoed that, stating, "The voids around the window and then the voids into the main cladding are very complex and interconnected. Question, is what you are saying that it's not obvious how you could have provided cavity barriers with that kind of arrangement? Answer, exactly. In fact, I've spent a lot of time trying to work out how one could." In her Module 1 evidence, Dr. Lane, in oral evidence, was similarly cautious. She said, "So I don't even want to get into if the cavity barriers had been there, could something else have happened?" Question, you are clear, are you, that cavity barriers can be effective around windows, even in a rain screen system? Answer, no, I've never said that, and I'm not going to say that now. In his phase 2 report, Mr. Hyatt offered his view of how a system could be designed. Though he describes it as an outline, it is extremely bespoke and goes much further than what would normally be described as a cavity barrier or fit into what is contemplated by section 9.13 of ADB. Having set it out, Mr. Hyatt is extremely careful not to assert that this scheme, despite its complexity, would be successful in containing fire, stating that it would require considerable further input following dialogue with other specialist consultants and the building control department in order to be developed into a robust scheme. Mr. Hyatt, in oral evidence, did consider that the complex scheme might have given time and insulation protection for some period, although he could not be specific about it. The conclusion must be that it would take an exceptionally skilled article a long time to come up with such a scheme, and that in any event, its likely protective impact would have been at most speculative. So although, for the reasons already stated, Mr. Ashton's answers to the issues raised about cavity barriers were correct, and Exova are not properly to be criticised for not going further. Even if they had gone further, issues have arisen on the expert evidence as to A, the effectiveness of cavity barriers as a matter of principle in rain screen systems, dealt with in the Module 2 written closings, the protection of window cavities in rain screen systems, and especially in the configuration installed at Grenfell Tower, which suggests that the escape of flames around the windows and into the cavities could not have been prevented. I'd like now to move on to 4 other topics that have been the subject of some comment. First of all, Exova's position after Ryden's appointment. First, the impact of Ryden's appointment in March 2014. From that point, they had overall responsibility that covered the appointment of consultants, and they elected not to appoint Exova or any other fire consultant. It included an obligation to complete outstanding points in the employer's requirements, among them the statement that external fire spread was subject to confirmation in a further report. Dr. Lane's review is that all this changed nothing. Merely to state that proposition begins to suggest its unreality, and the facts bear that out. First, the starting point. Exova's retainer letter recognised that the extent of any contribution that might be expected at the post-contract phase was uncertain. Mr. Ashton's evidence, uncontradicted, was that it wasn't unusual for contractors simply to drop the fire engineer. Secondly, the practicality. Mr. Hyatt recognised that post-novation, it would have been impracticable for Exova to provide such ongoing advice. With no authority and no relationship, Exova was not in a position to simply muscle in and express views. Ryden controlled the project as a whole, and with it all the documents and designs and meetings and flows of information that a fire engineer would have needed to be part of it if it was to play a full role. Thirdly, the knowledge and understanding of the parties at the time. The TMO had appointed Exova pre-contract. Post-DNB award, Ryden told the TMO that it would look into the possibility of a post-contract appointment, implying a recognition by both that there wasn't one in place. Ryden, having said that they would look into it, the matter being raised at six meetings, decided that they would not. Later in 2016, it was made clear to Ms. Williams in the TMO that Exova's strategy was a pre-tender document, not since updated. And likewise, it had been made clear many months previously to building control that it had been overtaken by later changes in the design. When Ms. Williams wanted, when Ms. Williams wanted fire advice, her lacanal moment, it was to Ryden she turned, not to Exova. The TMO, an active client involved in overseeing the project, raised the issue with Ryden, then simply let it fall away and acquiesced in the non-appointment of Exova. Mr. Gibson and Mr. Williams were clear that the purpose of Exova's engagement was to assist Studio E. Apart from the existing building fire strategy, a separate agreement, every fee proposal, fire strategy document and design note was addressed from Exova to Studio E. There was no personal contact to speak of between Exova and KCTMO, either before or after the appointment of Ryden. The outline fire strategy reports were read by Mr. Soons, but no notice of them was taken by any representative of Ryden, Harley or KCTMO. The fact that Exova had been engaged to advise Studio E explains KCTMO's disinterest in the continuation of the contract with Exova post-Ryden's appointment. Right from the start, KCTMO's own interest was in fire assessment reports. It was their legal duty to obtain these under the RRO regime, and they've been using them for many years in managing buildings. Fourthly, the position in these proceedings. The TMO acknowledges expressly in its written open submissions that Exova was part of the team pre-contract, but not post-contract, though CS Stokes was. They accept that it was up to Ryden post-contract whether or not they wished to have fire consultant advice. Ryden's witnesses are clear about the parties on whom they relied, not Exova. Studio E know that Ryden needed to engage Exova if they were to remain part of the design team. TMO, Ryden and Studio E are the only parties who could conceivably have been party to an engagement with Exova. And the fact that, say, a subcontractor called or dropped a line to a fire consultant which had been involved on the project at an earlier stage on a matter of small detail on odd occasions spread over a 2-year period can have no bearing on Exova's status whatsoever. Now, Dr. Lane makes two rather clumsy attempts to get around that. First, as well as recalling some projects where she was novated, she says that on occasion, the employer chose instead to appoint her directly. In either case, though, that required a decision. Here, the TMO's decision was to entrust the matter to Ryden, and Ryden's decision was not to retain Exova. The fact that some of Dr. Lane's clients may have made different decisions on some of their projects is neither here nor there. Likewise, her having been appointed on other projects to review the employer's requirements for contractors or contractors' proposals for employers. As it happens, it was envisaged in this project that consultants would be novated, as happened, for example, with Studio E, or reappointed on altered terms, as happened with Max Fordham, who made an amended proposal in December 2013. Secondly, Dr. Lane lists everything that Exova did in the post-Ryden period and tries to equate it with the work pre-Ryden. But this is wrong. Two queries, one about a stair vent, the other about fire alarms, were answered with a single sentence each. 3 entries in Dr. Lane's table were a single chain answered in one paragraph. There were a couple of exchanges, as we know, in September and November 2014 in relation to the plans for the lower levels, so tying back to points that Mr. Ashton had commented on previously. The 2 cavity barrier queries again involved just 1 or 2 emails apiece. After the second of those, there was next to nothing else. And that which was raised no new issues. So we're talking about archetypally sporadic ad hoc questions, hardly examples of ongoing involvement as part of a design team. Thus, having already had but a limited role pre-contract, post-contract, Exova were, in a real and definite way, frozen out of the project. Next issue, the scope of Exova's duty after the Ryden appointment. It is important to understand the implications for Mr. Ashton's duty when, as in September 2014 and March 2015, he answered an ad hoc question. First, complete responsibility for the project was vested in Ryden and flowed down from there. Second, large parts flowed, for example, to Studio E across the whole project, or hardly in relation to the facade and so on. Not so Exova. What flowed from Studio E to Mr. Ashton was a handful of disparate, discrete queries. Doubtless he was required, as he accepted in his evidence, to take reasonable care when he answered a question in answering it. But that cannot have been a duty beyond the question that had been asked. To suggest otherwise is at odds with the reality of the project structure as everyone knew it to be. Certainly, it would be neither fair nor practical to suggest that he had, in effect, a choice between not answering the question at all or assuming responsibility for conducting a more wide-ranging analysis of the project and the cladding system as a whole. By answering a narrow question, assuming in effect the same duties or role as a fully retained and active member of the design team. Evidently, nobody at the time understood Exova to have been engaged any more broadly than the questions asked, and for the reasons already discussed, a full engagement was not something that Ryden sought. Then the existing building fire strategy. Dr. Lane makes a significant number of points about the existing building fire strategy. The great problem with these, apart from their intricate detail, is that it is nowhere said with any clarity what precisely was the consequence of the emissions, if indeed there was any. So, for example, much criticism was made of assumptions, but all of them were stated clearly at the time, and none of them has since been shown to have been wrong. The central and broad complaint appears to have been that the report did not deal with obligations under the RRFSO, but that was the separate function under that order of a fire risk assessment. The issues that needed attention to be drawn to at that very early stage in the process, such as means of access, means of escape, smoke ventilation, were indeed all flagged up and intelligently dealt with. The smoke ventilation deficiencies and suggestions for the upgrading of the system were dealt with clearly at section 3.4 of the report. The requirement for a fighting lift was referred to, and the need for investigations of one, the separation of the risers, ancillary accommodation entered directly off the firefighting shafts, and two, the separation of the residential accommodation and the non-residential accommodation via the central core were both clearly referred to. It is also worth noting that once a draft of the report was submitted, the ball was in the TMO's court, and the TMO seems to have been singularly disinterested. Mr. Anderson's evidence was that there was no legal requirement for a fire strategy, and he did not read it, his concern having been with the fire risk assessment, which was required. It is unclear that any of his colleagues read it either. And next turn to the Regulatory Reform Fire Safety Order 2005. We may return to that in Module 3. The point for here is simply to correct the error in Dr. Lane's approach. Although Dr. Lane places repeated emphasis upon the RRFSO in her report, it is surprising how flimsy the legal basis is for the duties she alleges. In her words, a consideration of the RRFSO is a requirement of any fire safety strategy of any building to which the RRFSO applies. She has assumed that all this will form the basis of Exova's scope of work and reviewed Exova's fire strategy report on this basis. Thus, she says, it was reasonable to expect that Exova's report would set out any fire safety management duties on which compliance with building regulations relied, and that any relevance to duties under the RRFSO be clearly considered and set out when making final recommendations in a fire safety strategy. Now, that on its face would cover all routine maintenance, which the TMO as responsible person already knew about, maintenance it was already carrying out, maintenance which was unaffected by the refurbishment. That goes well beyond Exova's fee proposal letters and well into the realm of the fire risk assessment. And it is wrong. The starting point is the acknowledgement in paragraph 0.13 of ADB that building regulations do not impose any requirements on the management of a building. ADB goes on to say that in developing a fire safety strategy designed for a building, it may be necessary to consider the way in which it will be managed, explaining that a design which relies on an unrealistic or unsustainable management regime cannot be considered to have met the requirements of the regulations. It therefore gives the example of a design which might make a building's maintenance too difficult to be realistically managed. There is nothing to suggest that this threshold was reached in the current case. Essentially, the management duties of the responsible person were no more onerous or unachievable after the refurbishment than they were before. So Dr. Lane has imposed into a report on compliance with the requirement of building regulations the subject that the guidance says quite clearly is not a requirement of the building regulations, but which is covered quite separately in the fire risk assessment. Then I turn to Regulation 38. As to that regulation, Dr. Lane says, "It is my opinion that Exova committed themselves to providing adequate guidance on how to comply with Regulation 38. In fact, Exova's fees proposal did not refer to Regulation 38. Dr. Lane's proposition, which relies on assertion rather than any regulatory provision binding on Exova, or any guidance saying more than that the fire strategy report and drawings should be included as part of the Regulation 38 information, is not sound. Regulation 38 obliges the person carrying out the work, in this case Ryden, to hand information over to the building's responsible person, in this case KCTMO. Exova's role was never to advise Ryden on its obligations to KCTMO. The information must be handed over no later than the completion of the work. In other words, RIBA Stage K. Neither of Exova's fee proposals contained any reference to Regulation 38 or any provision at all in relation to beyond RIBA Stage F. Beryl Menzies explains that the relevant 2000 guidance indicates that compliance with Regulation 38 involves assembling a package of as-built information. Nothing even approaching material of the sort required under Regulation 38 existed at the time of any of Exova's reports. By Stage K, such information as Exova had been given was far out of date. Indeed, in her own lengthy report on Regulation 38, Dr. Lane makes only passing reference to Exova. Again, Dr. Lane should not be reading into a contract terms which are not there, even if it were permissible to give an opinion. For the reasons I've given, the one she gives is wrong. In any event, having made the criticism in relation to Regulation 38 at some length, Dr. Lane's position in oral evidence reduced to virtually nothing. She was asked why she would consider it reasonable to have expected Exova to address Regulation 38 when any handover was due, to be at the end of the project, and responded at day 61. So I think, as a reputable fire engineering company, they should raise the duty of others to comply with Regulation 38, regardless of when that is going to happen. So I'm being clear that the fire safety engineer must make other parties aware of their duty to comply with Regulation 38. And when you're writing a fee proposal, I would expect a fire safety engineer to make clear that's a looming issue for them. It's nothing more than that. So this is a very, very obvious, odd obligation to tell other parties that there'll be a duty of which those parties are already aware. Sorry, my cursor's gone. Sorry, excuse me, sir. Mr. Chairman, just for a second. I've got a small glitch. Just a minute. Thank you.
All right.
Glad somebody knows how to use tech.
Good. All right, carry on.
Okay, I'm ready to carry on. Means of escape. There was some lengthy questioning on day 62 about the duty of a fire engineer to have regard to the interests of vulnerable and disabled persons in drawing up fire strategies for high-rise residential buildings. Again, this is an issue that we may come back to at Module 3. Some criticism was apparently being directed at Exova, though after being taken to some of Exova's witness evidence on this issue, Dr. Lane did accept that ADB had no section which expressly dealt with the issue, and she did not suggest that there was any duty on a fire engineer other than to mention or consider the point. It may very well be, and we accept, the law here should be different and the guidance clearer, but it is clear that on any practical analysis, this is another issue that, independently of the refurbishment, was and is much more a matter for the responsible person under the RRFSO. Causation. The issue of causation is notoriously difficult, and I'm not going to get into a complex legal analysis, but I do want to set out a common sense summary of what Exova considers are, from its perspective, important considerations on the development of any causation argument. Starting point, Mr. Ashton's report was explicitly caveated and so was not capable of being interpreted as an endorsement for anything absent any analysis in a further report. Reliance. The advice was not in fact relied on. None of those involved in the selection of facade materials or the design of the facade system had regard to Mr. Ashton's report. Indeed, it's not even clear that any of them, other than Mr. Soons, had read it. Secondly, responsibility. Mr. Ashton's report formed part of the employer's requirements under the D&B contract between KCT&O and Dryden. By a negotiated term of that contract, Dryden assumed responsibility for any omissions or errors, deficiencies in the employer's requirement. This was a stated omission. Dryden, having been appointed in March 2014, specifically chose not to appoint Exova. All of the departures from guidance, breaches of building regulations were decided and implemented after that date. Even if one looks back to earlier steps, the considerations that took place before those decisions were made, the whole history leading to the selection of uncompliant materials is a narrative of steps by others without involving Exova. So, pre-contract, the consideration of alternative materials which might be substituted for compliant zinc Proteus rain screen panels. The inclusion of possible alternative panels in the NBS as presented to bidders. At the time of and post-contract, the discussion of value engineering with Dryden, both pre and post-appointment, including specifically the savings which could be achieved by substituting ACM for zinc. The selection of ACM instead of zinc Proteus rain screen panels. The selection of PE cord Rainabond by Harley. The choice of RS5000 made by Harley and approved by Studio E. The choice of Kingspan K15 insulation made by Harley and approved by Studio E. Detailed design work incorporating those materials done by Harley and approved by Studio E. Speculation. As regards what would have happened had Terry's report indicated the requirement of ADB, as Dr. Lane says that it should have been, the factual evidence strongly suggests that the die was cast in favour of the change to ACM panels, whereas Studio E did not look to Exova to give substantive advice on the facade. They did seek such advice from Curtains, their structural engineer. Curtains advised to follow BS 81414, BR 135, routes to compliance, to use a tested system. That advice was ignored. The evidence at Module 2 indicates compellingly that all of the manufacturers, Arconic for Rainabond, Celotex and Kingspan for the insulation, set out to market their respective products as compliant under the building regulations and ADB for unrestricted use above 18 metres, notwithstanding that they were not. It appears from the evidence at Module 1 that Dryden and Harley were both accustomed to using Rainabond ACM panels and that they understood them to be compliant. It also indicates that advice from Exova was never expected with respect to specific materials, as does Dr. Lane's evidence on analysis. One particular feature I turn to now, which was the architectural crown. The crown feature at Grenfell Tower was highly influential in the lateral spread of the fire around the building, as Professor Bisbee's collated photograph showed so grammatically. Once the fire had reached the top of the building, its spread was led by the crown. The flame front at the top of the building advanced ahead of the lower levels, and in doing so, caused molten and burning polyethylene to drop onto the cavity barriers at lower levels, or projections within the columns, or simply onto the face of the rain screen panels at lower level, from which areas new lateral spread fires started to ascend. The design of the crown had not been addressed in the NBS specification or the employer's requirement, except by the reference TBC, before the appointment of Dryden. The design was carried out in or about mid-2015 by Studio E and Harley. It was a feature implemented for purely aesthetic effect. No consideration was given to the issue of fire safety. No mention was ever made about it again on this critical and critical and causative issue, like Exova, was simply ignored. Misdirection resulting from design disorganisation. A small but telling example of a failure of basic design coordination lies in the plans themselves. In September 2014, the drawings which Harley, through Kevin Lamb, had created continued to indicate that the exterior range screen was zinc and did not define the nature or make of the exterior insulation, notwithstanding that the materials had by then been finally selected. And this was a reason why Terry Ashton may not have noticed after, or believed after September 2014, to think that the cladding was zinc or that the insulation was Celotex. What is more remarkable is that the plans were never altered so as fully and accurately represent the exterior materials. Even at the end of the project, the Studio E Harley as-built drawings continued to depict the rain screen material as zinc and to leave the insulation unspecified. Ben Bailey of Harley was quite unable to explain this. Core participants. I now turn to the written submissions of the other core participants. The issues they raise, where they criticise Exova, which by no means all do, were foreseeable. Where and why we disagree is apparent from our own written closings. Many of the criticisms refer to or ally themselves with Dr. Lane has said, which we have also, of course, dealt with in both our written and today's oral submissions. We therefore confine ourselves to a very few issues. Whilst Dr. Lane, I'm going to start with the issue of reliance. Whilst Dr. Lane at significant points does not even mention the second part of the much quoted paragraph 3.14 of Exova's outline fire safety strategies, a number of the core participants' closing submissions seek to suggest that paragraph 3.1.4 gave rise to a false sense of security or that it was misleading. This argument is wrong. The words used were as follows. It is considered that the proposed changes will have no adverse effect on the building in relation to external fire spread, but this will be confirmed by an analysis in a future issue of this report. On its face, this was perfectly clear. It was voicing a provisional opinion, but was subject to confirmation by analysis in a subsequent report. Mr. Soons understood it as meaning that it was too soon for them to comment, and that Exova would obviously need full details to be able to provide an analysis, contemplating that the next or subsequent stage, when the information became clear, would be that point. The use of the word confirm is very common in ordinary speech, often in the context of arrangement, such as Tuesday at 8 p.m. looks all right, but I will confirm tomorrow. That does not mean I will definitely say yes, otherwise it would not require confirmation, but simply I will confirm one way or the other. In both this simple example and in the sentence in the report, it is the word but which spells out the provisional nature of the statement and the fact that it cannot be relied upon until confirmed. There is little evidence in any event that anyone actually read the report. Nobody at Ryden or Harley could remember doing so. Nobody at KCTMO could remember to do so. Ryden appear to accept that they had significant contractual liabilities, but seek to put forward two arguments. First, that in this inquiry, the issue of legal liability is not an issue. So instead, the tribunal needs to look at the issue of responsibility, not by reference to legal liability, but in the sense of deserving of blame. Secondly, that the standard of conduct required of Ryden under their contract with KCTMO was the reasonable skill and care to be expected of a professionally qualified and competent design and build contractor, meaning that the yardstick of blame in their case appears to in fact be the same as the test for breach of contract. They also rely on the fact that it was and is accepted practice that delegation of specialist tasks to subcontractors and professionals is the norm in D&B contract. These three propositions have no exculpating effect on their dealings with and in relation to Exova. Engagement of consultants means taking reasonable care to recognise the areas in which the contractor does not have the requisite skill, identifying that those skills are required and ensuring that they are obtained. Ryden knew they had no fire skills. They were advised on several occasions by others in the design team to instruct a fire consultant and stated that they would do, but never in fact did so. This was not because of any actual consideration of the facts, but because it was their preordained policy not to instruct fire consultants at all on D&B contract work. In this case, they plainly primarily relied on their own and Harley's experience of using Rainabond ACM cladding on residential blocks in London. Thirdly, having achieved tender success based on the use of ACM and its associated cost savings, they argued forcefully before the planners that ACM was an appropriate material to use on the exterior of the building and were committed to its cause, committed to its use at Grenfell Tower. To use Ryden's approach, they are to blame for ignoring their own lack of experience on fire matters in approaching the issue of delegation. They are to blame for having disregarded the advice of other parties and Studio E in relation to the engagement of a fire consultant. They are to blame for following a policy which a professionally qualified and competent design and build contractor experienced in the carrying out of work of a similar size, scope, value and character and complexity to the Grenfell Tower would not have employed. They are to blame for putting financial self-interest before all other considerations and never giving fire safety a second thought in the process. Concluding comments. Now, I do not say on behalf of my client that there is nothing that can be criticised. What I've sought to demonstrate in our written submissions and to reinforce today is that it involved a series of decisions on materials and costs, contemplated at the pre-contract phase without consulting a fire engineer, made and implemented post-contract, having pointedly decided not to engage a fire engineer. I recognise that inevitably our submissions are focused on our dealings in the case. However, I do wish to say that we are not so preoccupied by and immersed in our own submissions that we forget the bigger picture of why we are here. We are here because 72 people are not, leaving behind them a whole community scarred and grieving. We also remember how these proceedings started with a deeply moving and fitting tribute for the deceased in a series of memorial hearings. It would therefore be wrong of me to finish in any other way than to express sorrow for those who are gone and profound sympathy for those they have left behind. So, Mr. Chairman, I believe in time those are my submissions and I have nothing more to add.
Well, Mr. Douglas, thank you very much. You have been economical in your time, and you've given us a lot to think about. So we're very grateful to you. Thank you very much. At this point, we'll take the morning break. The next statement is to be made by Mr. Stephen Hockman, Queen's Counsel, on behalf of Arconic. He was scheduled to make his statement at 11:45, but I think that if he's able to make it at a little earlier, we'll come back at 25 to 12, take the usual 15-minute break now, and hope to see Mr. Hockman then or shortly thereafter. Thank you very much. 25 to 12, please. Well, welcome back. The next statement is going to be made by Mr. Hockman, Queen's Counsel, on behalf of Arconic. And I can see you on my screen, Mr. Hockman, so I hope you can see us and that we can hear each other. Can you hear us?
Yes, good morning, sir. I can, and good morning to your colleagues.
Good morning. Well, it's good of you to make yourself available a bit early. I'm sorry that we made rather faster progress than we hoped, but thank you for becoming available a bit earlier. If you're ready to make your closing statement, then we're ready to listen. Thank you very much.
Thank you. We are very grateful for the opportunity to make this oral closing address relating to modules 1 and 2, and would like to begin by reiterating our sympathy for all those affected by the Grenfell fire, especially those who've lost loved ones and all others who we recognise will have been affected in so many different ways. Nothing that I can say will alleviate the effects of the tragedy, and indeed I'm conscious that my remarks may be felt by some to have the opposite effect. All I can do is to remind those listening, as I have done in the past, that if this inquiry is to arrive at a true and fair outcome, it is absolutely essential that it should hear the perspective of every core participant, including those whom we represent. Only in that way will the inquiry have a sufficiently full and balanced picture of the material upon which its decisions fall to be made. A moment ago, I used the phrase full picture, and I am, of course, not oblivious to the concern expressed by some that our clients have failed to do their best to provide the inquiry with the information which it seeks. I do nonetheless reiterate the assurance that we have done everything that we can to provide such assistance, notwithstanding the constraints facing us. As regards documentation, it is indisputable that we have provided detailed witness statements and many thousands of pages of relevant documentary material. Above all, we facilitated the attendance of the company's president, Mr. Claude Schmidt, who gave evidence over nearly 5 days earlier this year and was thanked by you, sir, for his contribution. A key constraint that faced the company which we represent was, as you know, the French blocking statute, which expressly prohibits the release to a foreign judicial authority of almost all the information which the inquiry legitimately requested. To assist the inquiry in overcoming this problem, we engaged with it from the outset in order to try to find a solution. We proposed, and the inquiry agreed, that as regards documentation, this could be achieved by the provision by us to the Metropolitan Police Service of relevant written information within the framework of a European investigation, a process which did not involve the contravention of the French blocking statute. The transfer of all this information to the inquiry then took place routinely pursuant to the memorandum of understanding between the MPS and the inquiry. The fact that after taking their own separate advice, certain witnesses have not felt able to attend for oral questioning is emphatically not something which can be laid at our door, and indeed we've been assured that counsel to the inquiry, if and when he makes a closing statement, will make no reference to, and certainly no criticism of, the decision of those witnesses not to attend. So we hope that the inquiry will treat these submissions, like those of other core participants, as being made in good faith and as being made with the intent, as I've mentioned, of enabling the inquiry to do justice to all concerned. In case anyone has any doubt as to the applicability to these proceedings of the French blocking statute and the risks involved in a contravention of that legal provision, we have now provided the inquiry with an independent confirmatory opinion by a distinguished French legal expert. We hope that this may be made available to core participants on relativity, and we know that the panel has had the opportunity to peruse it. This, we submit, should lay to rest any lingering suggestion that the company has somehow taken inappropriate advantage of this legal provision in order to defeat its own obligations towards the inquiry. Turning now to the substance of my oral submissions, I want to begin, if I may, by making some broad general points which will underpin the more detailed arguments which will follow. My first general point concerns the scope of the inquiry itself. The evidence and the arguments have, of course, ranged far and wide, but at the end of the day, and as is clear from its terms of reference, this inquiry is concerned with the causes of the fire at Grenfell Tower. That fire was a specific and utterly tragic historical event, and we're confident that the inquiry will wish to limit itself in its findings to an analysis of those causes. A recognition of the terms of reference enables one to make two further points about the scope of the inquiry. First, the terms of reference do not extend so as to permit a wide-ranging and unlimited review of the history of particular businesses, unless relevant to decisions made in connection with the events leading up to the fire. Still less do the terms of reference allow a wide-ranging and unlimited review of the use of particular products with regard to their combustibility or otherwise. In any event, and this is a point to which I shall return, the evidence does not permit the making of findings on such a broad basis. There is, however, a further point which arises from the terms of reference. Their effect is to mandate the inquiry to consider the causes of a particular event. The inquiry is, of course, precluded by the Inquiries Act from making any determination of civil or criminal liability, though clearly that does not preclude the making of findings of fact pertaining to the responsibility of particular human or legal persons. Our submission, however, is, and it's a point that we made in our original opening address to you, that findings in relation to responsibility have to be made on the basis of the facts as known at the time and on the basis of the standards as they were reasonably believed to apply. Findings in relation to responsibility should not be made on the basis of knowledge or standards applicable today after the event and after much subsequent public and private scrutiny. Again, this is a matter to which I shall return. The next broad point to which I now turn is that the company which we represent manufactured and supplied a number of different products, but these products were universally sold in unfabricated form. Although general guidance was given as to possible methods of fabrication, the company could not and did not dictate methods of fabrication, let alone guarantee the performance of its product in any particular fabricated form. Furthermore, it's an obvious and fundamental fact that the product being manufactured in the form of a flat panel would have no use or purpose on its own, at any rate in connection with architectural use. It was and was known to be inevitable that the product would be used in combination with other materials, and that such combination of materials would be fitted together in accordance with a specified design. Clearly, the company had no control over the choice of the other materials, let alone the arrangements for the fitting together of those materials in combination. Perhaps the most crucial distinction which the inquiry, as we respectfully submit, must acknowledge is the distinction between a product such as this company supplied and the facade system within which, in architectural use, the product was deployed. Again, this is a point to which I will return. As regards the supply for Grenfell Tower, the sale in France of the raw panels was to CEP, who in turn brought the panels into the UK and was under a duty of care when ordering the product to assess it and ensure that it was suitable for the purpose for which, as they were aware, the product was intended to be used. As appointed fabricator, CEP was then responsible for cutting and fabricating the panels in accordance with the design principles set out by the architect Studio E, and then providing such fabricated panels to those responsible for their installation, namely Ryden and Harley. As I shall explain, at least half of the panels were fabricated in a wholly unorthodox manner that was clearly distinct from any fabrication used for the purpose of testing and was distinct from any method of fabrication contemplated by this company. The next broad point that I want to make is that the manufacture and supply of ACMPE was at all material times lawful, both in France, where the product used for Grenfell Tower was in fact sold, and in the UK. I shall develop this point briefly in the course of this oral closing, though the legal analysis underpinning the submission is set out more fully in our written closing. The next general point follows logically from everything that I have said so far. Decisions as to the choice and use of a particular product in a facade system, decisions as to the design of that system, and in particular, the assessment of the combustibility and safety of the facade system, had to be a matter for those concerned in the design and construction of the facade. In relation to this point, we submit that the inquiry will wish to take great care in its approach. The fact that the refurbished facade at Grenfell Tower included combustible panels did not in itself mean that the construction failed to comply with the relevant regulatory regime or that the facade system as a whole was unsafe. It is our firm submission that ACMPE was capable of being used in a safe and compliant manner, just as combustible facades have been a feature of building design throughout the ages. Indeed, we would submit that the inquiry is not empowered by its terms of reference, nor equipped by the evidence provided to it, to conclude that ACMPE could never be used in a safe and compliant manner. Such a finding would involve a wide-ranging review of a huge volume of international material, which the inquiry has not undertaken and could not undertake. Moreover, there are hundreds of examples of buildings which had been clad in ACMPE and had received regulatory approval both in this jurisdiction and elsewhere. The inquiry would have no basis for concluding that in all these cases, fundamental mistakes or misunderstandings occurred in the past. It follows as a matter of inexorable logic that the tragic outcome of the Grenfell Tower fire resulted not from the use of ACMPE, but from the way in which it was used. In other words, its use in combination with a wide range of other combustible materials, especially those surrounding the windows, which ought to have delayed the escape into the facade system of a small internal fire in a particular flat long enough to allow the fire brigade to extinguish it. It follows, again, inexorably from the foregoing, that the responsibility for the fire and for its effects lay with those who decided on the choice of materials and the design and implementation of their relationship with one another. It also lies with all those who ought to have been concerned with fire safety and fire precautions in the building as a whole, and with the methods of firefighting deployed. It is far too easy, but also wrong and deeply unfair, to try to pin the blame on the manufacturer of a particular material, which at the time, and I stress at the time, was engaged in a lawful process of merchandising of a product which cannot be demonstrated to have been regarded at the time as necessarily inappropriate or unusable. I want to make two further broad general points before moving to more specific submissions. The first concerns the BBA certificate, the wording of which was, of course, the responsibility of the BBA. There was much debate in the evidence as to whether a particular proposition within the certificate was misleading. And as we have done in our written submissions, I'll be addressing you in detail on this in due course. For now, let me submit that taken as a whole, the BBA certificate which related to the ACNPE panels, in other words, to the product, and not to the wider system in which they were used, was not misleading. Secondly, and in any event, from 2014 onwards, the company took steps to advise customers as to potential issues with regard to ACNPE, particularly in certain fabrications, and at the same time, results of testing in particular systems were exhibited on the website of the testing body, the CSTB. To put the matter at its very lowest, it was therefore at least open to anyone involved in the construction of the new facade system at Grenfell Tower to seek and ascertain any relevant information about the fire performance of the product supplied, whether by interrogating the manufacturer or by checking with the CSTB. The true facts are that those concerned probably paid no attention to the BVA certificate, or if they did, they wrongly treated the reference to Class 0 as a guarantee of regulatory compliance. On the contrary, it is clear that a holistic fire assessment was absolutely necessary in this case, and that such an assessment, had it been undertaken, would have led to the rejection of the design, not least because the combustible insulation did not comply with paragraph 12.7 of approved document B. We believe that the insulation covered approximately 2/3 of the facade, compared with only 1/3, which was covered by Rainabond panels in any sort of conventional fabrication. I now want to make some more detailed submissions about the legal context in which the company supplied its product to customers. It is, we submit, indisputable that it was lawful for the company to place its products on the market in France, and we have not heard any suggestion maintained to the contrary. The product used in the Grenfell Tower refurbishment was in fact sold in France, and under EU law it followed that the product could also be lawfully supplied in any EU jurisdiction under that description. That is because the provisions of the EU treaties on the free movement of goods have been interpreted by the Court of Justice as requiring member states to allow products lawfully placed on the market in one member state also to be placed on the market in another, subject only to limited powers of intervention in order to satisfy imperative public policy requirements, including those related to public safety. As regards supply in France, the use of the products in a construction project would of course require compliance with relevant French construction law. As I mentioned earlier, EU law allows member states certain powers of intervention to satisfy imperative public policy requirements, including those relating to public safety. Whereas is the case here, there is an absence of harmonizing rules at European level, then it's for each member state to decide on its intended level of protection of human health and life. In England and Wales, this has been done through the enactment of building legislation. This does not regulate the supply of products. Rather, it regulates the way in which products are used in building work, and it imposes duties on those who carry out the building work. And the legislation, of course, includes the Building Act 1984 and the Building Regulations 2010. It's worth stressing that the requirement in the 2010 regulations at B4, namely that the external walls of the building shall adequately resist the spread of fire over the walls, must, we suggest, mean adequately to achieve the statutory objectives. In other words, adequately to ensure a reasonable standard of health and safety in all the circumstances, and to ensure that, as necessary, occupants can either stay put as a result of effective compartmentation, or if this is not possible, can exit or be evacuated safely in the event of fire. It is moreover clear that matters such as effective compartmentation, a necessary precondition of the efficacy of a stay-put policy. The presence of fire detection systems, fire alarms, means of escape, and other factors are relevant when assessing adequacy. Approved document B at paragraph 0.33 in the general introduction lists a wide variety of measures which might be utilised in order to secure compliance with the statutory requirements. These include such matters as automatic detection and warning systems, means of escape, measures for smoke control, the adequacy of the structure to resist the spread of fire, one but not the only factor, measures for fire extinguishment, and staff training. It can be seen that the approach of the regulations is a holistic one, and that no absolute obligations were imposed as to the type of product that could be used in the construction of a facade system. Certainly, there was no absolute prohibition at the time on the use of combustible materials. We submit it follows logically from what I've said, and was undoubtedly the case, that there was no legal obligation on a supplier to give a warning that ACMPE was combustible. Moreover, it is obvious and a matter of common knowledge that polyethylene, a plastic, is combustible. And the following statement appears in a standard textbook on product liability and safety, which states as follows: the need for a warning may depend on whether a danger is hidden as opposed to being either obvious or a matter of common knowledge. There is no need to warn an adult that petrol is explosive and pork is dangerous when eaten raw. When a danger is of this type, all relevant duties will be discharged by supplying a sound product into the hands of a person who could be expected to deal with it safely. In any event, moving on from what I've said already, those involved in the construction project, not only the fabricator as purchaser, but others concerned, were in the events which happened on notice of the need to check and confirm that the use of the products was appropriate by means of a fire safety assessment by a qualified fire engineer. I refer, for example, I'll be saying more about this in a few minutes, I refer, for example, to section 6.5 of the BBA certificate itself, to the effect that in relation to resistance to fire, the performance of a wall incorporating a product had to be subject to testing. And moreover, as I've already mentioned, the company took steps from 2014 onwards to provide additional relevant information. And I'd add at this point that, as Mr. Seward pointed out yesterday, those concerned with the design and choice of materials who opted for ACMPE were on any view obligated to ensure that the design and choice of materials would ensure adequate compartmentation within the building. Those involved in the construction project are no doubt entitled to ask the inquiry to apply the legal regime as it existed at the material time. By the same token, an overseas manufacturer is entitled to make exactly the same request and to rely on the fact that the regulatory regime in this jurisdiction will be conscientiously applied by those to whom it does apply. An overseas manufacturer who sells the product in the jurisdiction of manufacture cannot be expected to second guess the national regime in another jurisdiction. Moreover, as we have repeatedly pointed out, and irrespective of the many criticisms of the then regime which have been and can be made, it's indisputable that on any view, the Grenfell Tower proposals in specifying combustible insulation rather than insulation of limited combustibility were in direct contravention of the linear route to compliance in the then regime as contained in ADB paragraph 12.7, and a recognition of this departure from compliance by the design and construction professionals would itself, if acknowledged, have led necessarily to a holistic fire assessment and to a complete revisiting of the use of the combination of materials which was in fact used. On the other hand, it is, we suggest, absolutely clear that paragraph 12.7 had no application to the ACM panels, this being the clear and, we would contend, indisputable evidence of Dr. Lane. Further, Mr. Sekula's report states that he would consider that paragraph 12.7 was intended to refer to gap fillers such as expanding foam fillers. He does not think that it was intended to refer to the core of an ACM panel, which he has never heard referred to as filler. He also thinks the reasonably competent contractor or product manufacturer would have had a similar view. Documentation disclosed in the context of Module 6 shows that in the immediate aftermath of the fire, government representatives, encouraged by Colin Todd, were proposing to claim that the use of the ACM panels was non-compliant by reason of paragraph 12.7. If that were the case, then subsequent legislation banning the use of combustible panels generally would hardly have been necessary. Some of the evidence before the inquiry relates to examples of cases in which fires occurred in buildings clad with what was or may have been combustible cladding. The extent to which such fires were or became matters of public knowledge is unclear. Many of the witnesses called before the inquiry claimed not to be aware of these fires, though some admitted that they were. Once again, this evidence needs to be approached with considerable caution. The inquiry will, we submit with respect, have to ask itself the question, what is the evidential relevance of this type of evidence? On any view, if such a fire involved combustible cladding, and if a witness was aware of that, then that would demonstrate that the relevant individual knew or ought to have known of the risk of such a fire occurring in other buildings. However, that inference does not take the inquiry very far because, as we submit, anyone acquiring ACM PE panels would be aware of their combustibility. A perusal of the BBA certificate, for example, including its express reference to the fire retardant alternative, would have made this clear. It would, however, have been wrong to assume that the presence of combustible cladding would in itself result in a failure to achieve adequate resistance to the spread of fire. In other words, to lead to a significant adverse risk to human health and safety. Professor Torreira pointed out in his Phase 1 report that in the cases he mentions where buildings had experienced large external fires, there were no significant injuries, let alone fatalities, given the wider construction features and fire protection features involved in those buildings. This is further evidence that the product was capable of being used safely, even in high-rise residential applications, if the appropriate cladding system was designed and adequate safety precautions incorporated into the building works. Against this background, it's understandable that suppliers of ACM-PE around the world continued to market the product, as indeed did others within the UK, who had a significantly greater market share than this company. As regards Rainabond PE, at the time that this product was sold for use as one component of the cladding system at Grenfell Tower, there was no awareness of any fires involving that product that had resulted in the loss of life or significant injury. Moreover, as I've already stressed, the same product had been used and had obtained regulatory approval for its use on hundreds of other buildings. The key to an understanding of this picture lies in the distinction which I drew early on in this address between the product itself and the way in which the product was used, in other words, the system. In those cases where significant fires occur, particularly if they led to any loss of life, it may be possible to infer that there were defects in the system which prejudiced health and safety. But one simply cannot infer from this that the product itself was unsafe, let alone that it could not achieve compliance in a particular regulatory regime. On the contrary, the only possible inference is that whether in this jurisdiction or abroad, compliance systems were repeatedly designed by qualified architects and repeatedly achieved regulatory approval by presumably competent building control officers. The inquiry cannot on the evidence conclude that ACMPE, albeit like many other historic and contemporary building components being combustible, was incapable of being used in such a way as to resist adequately the spread of fire, taking into account the various and wide-ranging factors which I have listed above. The panel may take the view that this analysis is consistent with a very interesting exchange which occurred last week during the evidence of Dr. Lane on day 170, when you, sir, highlighted the fact that significant elements of the original external facade at Grenfell Tower were comprised of non-combustible materials. Dr. Lane, in her phase 1 report, had identified these materials as including sliding windows and non-combustible infill panels, which did not promote the spread of fire over the external facade, although, of course, after refurbishment, the facade included the white alley-glaze infill panels that were highly combustible, and the windows and the alley-glaze panels, as it happens, covered an area at least equal to the area covered by the ACM panels. You were, I think, in that evidential exchange, making the point that one could not, in any event, regard the external facade as contributing to the concept of compartmentation. Dr. Lane responded to the effect that that was correct, and that as regards the external facade, the aim should have been, under the regime at the time, not to promote substantial spread of flame to multiple other compartments. From this, one can draw the inevitable conclusion that those concerned with fire safety at the material time, whether as expert fire assessors or in local authority building control, must have taken the view, in many instances, that combustible ACFPE, even though combustible, would not, in the context of the particular building design and configuration, promote fire spread to multiple other compartments. Moreover, to reinforce what I've been saying in general terms, there is in fact ample positive evidence of the potential safe and compliant use of ACMPE. Mr. Sekula himself has confirmed in his report, paragraphs 17, 10 to 12, that the use of ACMPE was not precluded by the regulatory regime at the time, and it is indeed possible that a building incorporating ACMPE, but designed to be in compliance with the regime and including all appropriate features, such as cavity barriers and non-combustible insulation, would have been in compliance. This is shown, for example, by the evidence as to the Taplow fire. The cladding system on the building at Taplow comprised Rainabond ACMPE cladding in rivet fabrication and rock wool insulation, which is non-combustible. The fire did not spread across the outside of the building because of the overall cladding system used. The precise features in the cladding system and construction of the building, most notably the fire breaks, contained the fire to a small area. Another, perhaps even more relevant example is the fire in 2010 at Sudbury House, Wandsworth, a 24-storey tower clad in ACMPE fabricated as cassettes, with mineral wool insulation, which CEP have confirmed was contained, like the fire at Taplow House. There have also been a number of fires in residential tower blocks outside the UK in which there have been no casualties, including those where fire spread was more rapid than it was at Grenfell. Professor Torero notes in his report that a comparison with other international events shows that the upward flame spread for the Grenfell Tower is among the slowest. An example, we think, is the torch in Dubai, which was clad in ACM-PE, though not this company's product. This would suggest that there was something other than the type of cladding which differentiates the buildings. For example, the robustness of compartmentation, and that it is such other factors which led to the vastly differing outcomes of the fire. In all the circumstances, we suggest that the emphasis placed by others on the awareness of various individuals within this company of the combustible nature of Rainabond PE is misplaced. Those within the company were entitled at the time to take a view which was clearly taken by hundreds of building control officers up and down this country, namely that the combustibility of the product was only one among many factors to be evaluated in assessing fire safety, and that if the systems and arrangements within the building as a whole were adequate to resist the spread of fire, then regulatory compliance and appropriate health and safety requirements would be achieved and fulfilled. And if there are those who suggest that the company should have gone further than giving warnings and should have withdrawn its ACM-PE products from the UK architectural market, as indeed it did following the Grenfell Tower fire, we say that that would have been unreasonable in the light of the potential safe and compliant use of ACM-PE, and in the light of the UK construction regime being an overseas regime so far as the company was concerned. Moreover, given the relatively small share of the Rainabond ACM-PE product in the UK market, that would simply have meant that unless the regulatory position in the UK was changed so as to ban or restrict its use, construction professionals wishing to use ACM-PE in their construction projects would have obtained it from one or another of the many other manufacturers who at that time were supplying similar products onto the UK market. Finally, on this aspect, we have noted that other core participants have made reference to a range of more recent product testing in which, as they suggest, the use of ACM-PE gave rise to less than favourable results. We reserve our position on these references unless and until any of this third-party testing is embraced and relied upon by the inquiry experts. For the present, we confine ourselves to the observation that the fact that particular results are obtained when a product is used in a particular configuration cannot by definition prove that it would be impossible for the product to be used in a compliant manner. It's precisely for that reason that one of the 4 routes to compliance involves a holistic fire engineering assessment of the particular project design under consideration. Furthermore, we must obviously reserve our position as to the long-awaited outcome of the experimentation work which the inquiry itself has been arranging, and upon which key conclusions in the Phase 1 report were acknowledged in part to depend. We would encourage the inquiry, if it can, to provide another progress report on this work and to make the results available as soon as possible for scrutiny by core participants. Now I want to turn, please, to deal in greater detail with the BBA certificate and its terms and effects. And this certificate and the dealings between the company and the BBA have assumed of course, considerable significance. It's not a legal requirement to hold a BBA certificate, which is seen as a marketing tool to assist sales. It was paid for by the company, and as part of that payment, the company was entitled to rely upon the expertise and judgment of the BBA when granting the certificate in the terms it felt were most appropriate. The certificate was, of course, drafted by the BBA, but we submit that if its contents had been properly considered and understood, the certificate itself would or should have ensured that those involved in the works to the tower were appropriately directed as to the use of the company's products. Not only did the certificate itself show clearly that the company could supply a fire retardant as well as a polyethylene product, but in relation to the latter, it contained accurate and precise information as well as clearly defined limitations as to its scope. It provided correct information as to the fire performance of which a panel would be capable, depending on the cladding system in which it was used, but made crystal clear that the performance of that system would depend on further specific testing. Moreover, as I've mentioned, no one reading the BBA certificate could possibly have thought it appropriate to incorporate ACMPE in the cladding system without conducting a holistic fire engineering assessment. We respectfully reject the suggestion that the company deliberately arranged for the certificate to apply to an individual panel rather than to a panel as subsequently fabricated by another business for incorporation into a cladding system in a particular configuration. Since the company would have no involvement in the design of the system, nor in the fabrication of the panel, it was natural and logical that the certificate should apply, as it did, to the panel itself. Now, before I deal in a little bit of further detail with the BBA certificate, I have to establish and remind the inquiry of some key points relating to methods of fire testing. Testing under BS 476 Part 6 and 7 is, of course, testing in relation to an unfabricated sample of the product, which is what the company manufactures and supplies. That form of testing, which may lead to a finding of National Class 0, does not involve a test of the fire performance of a fabricated product incorporated into a particular wall assembly. NC0 is, or at any rate has generally, if strictly speaking inaccurately, been understood as being a classification in relation only to the surface of an unfabricated product. An NC0 classification can, as we can see from other BBA certificates evidenced by the inquiry, can be achieved alongside different EN classifications. Now, as to EN classifications, European classifications, in broad terms, the EN 13823 test in particular is a test of the panels in a particular mocked-up system. The system in which the panels are assembled may vary from one test to another, not just in terms of the method of fixing, for example, rivet or cassette, but also in terms of the substrate used, the size of the cavity, and the particular arrangement of the panels and the size of the joints, in other words, the size of the gap between the panels. So if, for example, an ENB classification is achieved, it shows that the product, the panel, is capable of achieving an ENB in a particular system when fabricated in a particular way. But given the nature of EN testing, a classification such as ENB cannot be treated as achievable in all circumstances. This point has been made very strongly by counsel to the inquiry himself in questioning other manufacturers, and moreover in questioning Mr. Schmidt, the president of the company. Counsel positively asserted that there are a number of variables when one is conducting a test under the European system. For example, the shape of the product, the mounting, the substrate, the size of the air gap between the reverse of the rain screen and the substrate. It follows that any reference to a particular European class, whether in diagram 40 of ADB or in the BBA certificate or otherwise, could and should have been treated only as a reference to the class which the product was capable of achieving. No other proposition can logically be acceptable. Moreover, because the EN 13823 test relates to the testing of a product fabricated in a particular way in a mocked-up system, which may vary from one test to another, it follows that two or more EN classification reports can coexist in relation to the same product at the same time. And of course, it follows from all of the above, as the BBA certificate itself suggested, that the time to assess the potential use of the product in a particular context must be at the point of system assembly and by applying one of the routes to compliance. Now, let me apply these general propositions to the testing of Rainabond PE. We know that in 2005 and in 2011, panels of the product configured in a particular mocked-up system achieved ENB. As I've explained, this shows that the product was capable of achieving an ENB, although other and subsequent EN testing involving the product, in which the particular mocked-up system would have varied, did not achieve ENB. This is not inconsistent with the fact that in 2005 and in 2011, an ENB classification was achieved, and the obvious conclusion is that the product was capable of achieving ENB. The variable was not the product, it was the system into which it was incorporated. This point is illustrated by the written submissions of a number of core participants and by the questions put to Mr. Schmidt by your counsel, which have referred to variations in the width of the cavity between the cladding panels and any substrate. In the presentation by Dr. Lay on day 68, she helpfully referred to a conclusion in a 1994 report to the effect that a reduction in the width of a cavity will reduce the surface spread of flame over cladding material. This would appear inconsistent with the suggestion, which others have made, that in the testing process, the width of the cavity was originally increased artificially in order to improve the outcome. In any event, it is right to note that variations of this kind are inherent in a process whereby the tested system will vary from test to test. The width of the cavity may be only one of the differences between the tested system. As I've already said, the system in which the panels are assembled may also vary in terms of matters such as the method of fabrication and fixing, the substrate used, the particular arrangement of the panels, and the size of the joints. In other words, the gap between the panels. The fact that these factors may vary from one test to another is a feature of the EN testing process. What is important is that the CSTB, the recognized testing body in France, nonetheless confirmed and published on the website, published on its website the relevant classifications, including those showing that in a given system, an ENB result could be achieved, as well as others less favorable. Now I want to go on, if I may, to provide an analysis of the BBA certificate, including its purpose and scope, and the limitations of the representations which it contains. Insofar as behaviour in relation to fire is concerned, the BBA certificate could not and did not go further than to certify as to the surface of an unfabricated panel. The BBA proceeded on the basis that once the panel achieved an ENB rating in one testing scenario, that meant that the panel should be able to achieve an NC0 rating on testing for surface spread of flame. Moreover, the certificate contained a range of caveats as to the fire performance of a fabricated panel in a particular cladding system. In these circumstances, it was unnecessary and indeed irrelevant to provide additional information as to the fire performance achieved by panels in specified fabrications or systems. Such information was immaterial to the purpose and scope of the certificate as worded by the BBA and should have been understood by those who perused it. Now let me descend a little further into the detail of the wording, which I'm sure everyone recalls. The first page of the certificate expressly describes the panels as aluminium polyethylene composite and states that a panel may be regarded as having a class 0 surface. Following this, it refers the reader to section 6. Section 6.1 states that when a sample of a standard, that is, a PE grey-green product, was subjected to an EN test, it achieved a B classification. That product was therefore capable of achieving an ENB classification. As I've explained, this did not mean that an ENB classification would be achievable in all circumstances and irrespective of the method of fabrication and the other features of the cladding system. Section 6.2 then deals separately with the testing of a fire retardant sample. Section 6.3 then states that both products, that is, FR and PE, may be regarded as having a class 0 surface in relation to approved document B. The assertion in section 6.3 of the certificate that the product may be regarded as having a class 0 surface in relation to ADB is plainly a reference to paragraph 12.6 of guidance and diagram 40. Hence, the certificate was simply setting out that since the product was capable of achieving the requisite European class, it could also be treated for the purposes of compliance with the guidance as achieving the requisite national class. If the UK regulatory regime had not, in diagram 40, offered the option of equating European class B with NC0, the BBA certificate could not have been issued in the form it took, that is, in claiming that the product could be regarded as achieving NC0 for the purposes of ADB paragraph 12.6. By an amendment in 2002, however, references were included in ADB to European test standards in order to facilitate treaty provisions on the free movement of goods in the EU. Now, we recognise that the inquiry will in due course investigate and opine upon the wisdom of providing for the two alternative compliance mechanisms in diagram 40, which played a critical part in the decision-making of the BBA. On any view, there can be no criticism of this company for the decision of the BBA, which claims to have expertise regarding UK building regulations, to interpret and apply diagram 40 as it did. We would also stress that at the time that the product was sold to CEP for use on Grenfell, a valid ENB classification report existed, which showed that the product had achieved an ENB classification. We acknowledge that as Council and other core participants have observed, under European testing, some fabricated versions of the product failed to achieve a B classification. However, for the reasons I've set out, this was not inconsistent with the NC0 certification in the BBA certificate, this being a certification relating to the surface of the product, for which in a particular system and when fabricated in a particular way had been shown capable of achieving a B classification. Information as to the fire performance of other fabrications, and as I've explained above, there could have been, and at Grenfell Tower itself were, a large number of alternative fabrications and systems, would have been immaterial to the scope and purpose of the certificate. Then we come to section 6.5, which has been much underemphasized in the course of the hearings. Section 6.5 of the certificate states that for resistance to fire, the performance of a wall incorporating the product is not covered by the certificate. The BBA certificate at section 6.5 also states that the performance of a wall incorporating the product can only be determined by further tests. Section 6.5, we submit, is a provision of great importance and was clearly so regarded at the time by those concerned. Whilst there is, of course, a difference between reaction to fire and resistance to fire, it's clear that requirement B4 of the building regulations was crucially concerned to ensure that the external walls of the building had adequate resistance to the spread of fire. And section 6.5, in relation to this issue, makes explicit the requirement for further tests. From this there flow a number of important consequences. First, bearing in mind that the certificate was to certify only the surface of an individual panel, it was entirely logical and appropriate to include the caveat contained in section 6.5 that the performance of a wall system incorporating the product could only be determined by further tests. Second, given the incorporation of 6.5, it was in fact entirely unnecessary to include caveats within the certificate relating to the method of fabrication. Counsel for the inquiry suggested to BBA witnesses that it ought to have been made explicit that the test result in section 6.1 was achieved by a sample of the product in rivet fabrication, or more generally, that it should have been made explicit that this did not necessarily apply to all forms of fabrication. And we note in passing that BBA certificates relating to other ACMPE products did not have such references either. But it can be seen that section 6.5 has precisely the effect which counsel to the inquiry was looking for. Indeed, it expresses his caveats even more broadly. Thirdly, section 6.5 clearly shows that section 6.1 cannot be read as meaning that a sample of the product will achieve a B classification in any and every system. Cannot be read as meaning that a sample of the product will achieve a B classification in any and every system. If that were the case, then further testing would be unnecessary. It follows that in interpreting the certificate as a whole, and in particular section 6 as a whole, the suggestion that the reference in section 6.1 to a B classification, the suggestion that the reference in section 6.1 to a B classification was misleading is both incorrect and unfair. Then the certificate at section 6.6 goes on to state that cavity barriers should be incorporated, and section 6.6 also states that particular attention should be paid to preventing the spread of fire within a building, breaching the cladding system through windows and door openings. what more apposite warning could there be? It follows that the BBA certificate is cautiously worded. The reference to class 0 is expressly related to the surface of the product, and the certificate as a whole limits itself to specific examples of the product. Moreover, clear advice is given that the fire resistance of a cladding system incorporating the product is not covered by the certificate, but must be subject to further testing. It's also worth noting that the caveats and limitations in the certificate are consistent with the relevant guidance contained in approved document B, which I deal with briefly, Appendix A, paragraph 16, provided that any reference in relation to the surface spread of flame should be carefully checked. And it went on to say that small differences in detail, such as thickness, substrate, colour, form, fixings, adhesive, etc., may significantly affect the rating. These are caveats equivalent to that which is expressly contained in the certificate in section 6.5. Now, considerable stress has been laid upon the provision in the contractual arrangement between the company and the BBA, under which the company agreed to inform the BBA as to any change in the composition of the product or any change in other details affecting the validity of the certificate. We submit that these complaints lack substance, firstly because the composition of the product never changed, other than an immaterial change to the colour of the core, which would have been evident to the BBA on their visit to the factory at Mertzheim. And secondly, because, given the analysis I've set out in these submissions, and especially given the scope and purpose of the certificate in certifying as to the surface of an individual panel, it follows that system testing, of which the BBA may have been unaware, could not have affected and did not, on a correct interpretation, affect the validity of the certificate. Moreover, Mr. Gregorian, on behalf of the BBA itself, gave some important detailed evidence as to how the BBA certificate came into existence. It was clear beyond doubt from his evidence that although the certificate was produced at the request of the company, it was the BBA which decided on the information which they would need in order to compile certificates, and it was the BBA which decided on its contents. Those involved in the process on behalf of the BBA included not only Mr. Gregorian, but also Brian Haynes, now sadly deceased. Mr. Gregorian made clear that Mr. Haynes was experienced in the assessment of the fire performance of a product to be certified. Moreover, he had close links with the BRE, and in particular with their expert fire professional, Ms. Sarah Colwell. In the case of the certificate for this company, Mr. Haynes expressly referred the matter to Ms. Colwell. This was primarily for the purpose of confirming the correctness of the certification with regard to the back face of the panels. But in order to enable Ms. Colwell to do that, she was provided with the fire classification reports which the BBA had in their possession. It follows that Ms. Colwell herself must have been aware that the classification report obtained for PE in rivet format was being relied upon by the BBA. Unfortunately, no evidence has been adduced in Module 2 from Ms. Colwell herself, but it seems reasonable to infer that she was aware that the BBA were proposing to issue a certificate certifying that an individual panel could be regarded as achieving a Class 0 surface, and that she expressed no adverse view in that regard. In particular, it seems reasonable to infer that she did not advise Mr. Haynes that it was inappropriate to rely on the classification report, limited as it was to a particular mode of fixing, or that the BBA should seek fire testing results for other fixing modes. It would have been open to the BBA, knowing from the text of the certificate itself that there were other methods of fabrication and fixing, to ask for tests relating to other methods. The BBA clearly took the view that the method of fabrication should not have affected the external flame spread characteristics with which a Class 0 rating is concerned. As regards the purpose and scope of the certificate, on this issue, Mr. Gregorian's evidence was very clear indeed, that the purpose of the certificate was to provide an assessment of an individual panel and not to provide an assessment of the performance of the panel in fabricated form or in the context of the many variable cladding system. Mr. Gregorian made it explicit that the BBA were not intended to make any representations as to the performance of the product in fabricated form or in a cladding system as a whole. Such representations, as Mr. Gregorian repeatedly stressed, would have been irrelevant to the scope and purpose of the certificate. It must therefore follow, as a matter of indisputable logic, that although in a particular fabrication or cladding system, the fire performance of a panel could vary, the certificate was confirming the level of performance which could be achieved by an individual unfabricated panel. Any reading of the certificate which treated the certificate as confirming that in any and every mode of fabrication or in any or every cladding system, a given level of fire performance would be attainable, would clearly be a serious misreading and would attach to the certificate far more weight than it was intended to bear at the relevant time. In relation to the BBA certificate, Mr. Sekula is of the view that members of the cladding contractor's staff with technical or design responsibility should have read the certificate in detail. A reasonably competent cladding contractor would have ensured that somebody with technical or design responsibility had read the BBA certificate in detail to ensure that a product was appropriate for its intended use on a project, and that would involve reading the whole certificate in its entirety and not just any summary on the front. Here, although the front page may have given the impression that the product had a Class 0 rating without qualification, on turning to Section 6, it was apparent that this contained vital information about the details and limitation of the fire testing carried out. Mr. Sekula considered that a reasonably competent cladding contractor should have read Section 6 in full, and had they done so, they would have been alerted to the fact that the BBA certificate was very specific in its scope. He also said that the cladding contractor should have had a dialogue with the manufacturer to find out what background information there was to the certificate, such as underlying source tests and test data. Such inquiries made at any time after February 2014 would have highlighted relevant issues in relation to the cassette fabrication. As regards the awareness of a reasonably competent cladding contractor as to the nature of the PE core, Mr. Sekula said that by reason of the known fires involving the use of such material, it ought to have been understood that the material was quite easily ignited and combustible. And in the oral evidence, for example, Mr. Ray Bailey, he confirmed that following the Chalcots fire, the Tapman fire, he learned that ACN would burn. Since the certificate related to the reaction to fire of the surface of the unfabricated product and the potential spread of fire across that surface, the statements in the certificate would not, or at least should not have changed in the light of further fire performance information relating to the surface following the issue of the certificate, unless there was evidence that the fire performance of the surface of the unfabricated product had changed, which it had not. And as I previously argued, an EN test result relating to the fire performance of the product in a particular cladding system would demonstrate and could demonstrate only that the product was capable of achieving an EN result as part of that system. Consequently, further EN test results would not have impacted upon the classification referred to in the BBA certificate. We therefore submit that less favourable test outcomes in a system involving cassette fabrication did not detract from the fact that the product had achieved and was capable of achieving EN reading, and therefore the NC0 classification referred to in the certificate remained appropriate. So in moving on, as I now do, to discuss briefly the evidence of Mr. Claude Schmidt, perhaps I can reassure you and your colleagues that I'm on track to finish by my allotted deadline of 1:15. I hope that is appropriate.
Well, I thought since you started 10 minutes early, you might finish 10 minutes early, Mr. Hockman.
I'm sorry, I can't promise to be able to do that.
All right.
I'll do. Apologies. It's now necessary to provide a summary of and commentary upon the content of the oral evidence of Mr. Schmidt, insofar as it bears upon the issues that I've been discussing. He was, of course, being asked questions in English and responding in French. Mr. Schmidt was subjected to a series of leading questions based on the premise that, contrary to the case made in these submissions, the reference to ENB in section 6.1 of the BBA certificate was misleading. Those questions were put in a manner which, as later became clear, contained in the English version a crucial ambiguity. However, irrespective of the manner in which the questions were put, they were, in any event, based on a false premise that reference to specified fabrications or systems was material to the scope and purpose of a certificate, which identified the fire performance which had been and therefore could be achieved by an individual panel. The company's case, as foreshadowed in its opening statement to the inquiry on the 5th of November 2020, and as supported by Mr. Gregorian, is that such reference was immaterial and that no conclusion adverse to the company should therefore be drawn from the answers to such questions. The following summary of the oral evidence of Mr. Schmidt illustrates the false premise on which the questioning is based and underpins the submission which is made on the company's behalf that extreme caution is required in dealing with his oral evidence. Time does not permit me to repeat the fully detailed review which is found in our written closing. On day 91, Mr. Schmidt was asked to agree that the BBA certificate presented both the rivet and cassette fixed variants of Rainabon 55 PE as Class B. It was also put to him that this was a false statement so far as concerns the cassette fixed variants. Regrettably, these propositions, as we respectfully submit, were themselves false. As Mr. Gregorian emphasised, and as is clear from the certificate, in particular from section 6.1, the certificate related to an individual panel and not to what counsel described as either the rivet or the cassette fixed variant. Of course, the company does not supply a rivet or a cassette fixed variant. It supplies unfabricated panels. In response to these questions, Mr. Schmidt began by saying that he was in doubt about the question and that previously it was said that one wasn't going to be referring to cassette or rivet. Mr. Schmidt was then asked whether Arconic accepted responsibility for the sale of Rainabon 55 PE to the UK market on a false basis as to its European fire classification. Once again, this question was itself put on an incorrect basis. Mr. Schmidt's response was that the information that was on the BBA certificate was not false, but that it did not mention the different reactions to fire depending on whether the system was rivet or cassette. The company's case is that on a correct interpretation of the scope and purpose of the certificate, it was unnecessary for that reference to be made. It's now necessary for me to explain why many of the questions put to Mr. Schmidt contained a crucial ambiguity. On day 94, counsel acknowledged that there was something that needs to be corrected. He acknowledged that the company's lawyers had stated that the English word misleading in his questions had been wrongly translated into French. It had been translated using the word erroné, which means incorrect or erroneous. The company's lawyers had in fact suggested in an email to the solicitor inquiry that the word misleading should be translated so as to show that the word carries the meaning in English, deceptive. Instead of adopting this suggestion, counsel told Mr. Schmidt that the question would be translated as wrong such as to lead a person into error. A number of examples were then put forward from the earlier question, and Mr. Schmidt was invited to confirm that in those cases he would agree to the use of the word misleading in the sense of wrong such as to lead a person into error. In response, Mr. Schmidt made a number of comments. First, he stated that it wasn't done consciously because there was a doubt with regard to the fire certificate 5B. Then he stated his belief that the failure to mention test 5B was not deliberate, but that there had been a misunderstanding or bad understanding with regard to the results of that test. In summary, therefore, we would point out that Mr. Schmidt was not involved in the creation and issue of the BBA certificate, nor was he or is he an expert in fire risk assessment. He did initially agree with questions put to him in leading form, suggesting that the reference to the ENB result in section 6.1 was misleading. But these questions were, as we submit, based on an incorrect interpretation of the BBA certificate. In any event, the evidence was later revisited as a result of an ambiguity in the process of translation. We pointed out that the word misleading in English can imply deliberately deceptive conduct, whereas the interpreters had translated the word as meaning incorrect or wrong leading to error. In later questioning, counsel made clear that he had intended to advance the latter interpretation, and Mr. Schmidt made clear that it was on this basis that he accepted what was put to him. He stressed that he had not intended to accept that the company had acted deliberately to mislead, and he pointed out the various caveats in the certificate to which we've drawn attention. We therefore submit that in accepting that, as we all now know, the ENB result was incorrect and inapplicable to the cassette fabrication, Mr. Schmidt was doing no more than accepting the obvious. The inquiry would not be entitled to infer that the reliance on the ENB result came about through any form of deceptive conduct, or that read as a whole, the certificate was misleading. At the time, the certificate was intended by all concerned to relate to a panel in unfabricated form, and it was therefore entirely legitimate to provide, as an example, a test showing the result of which the product was capable in a given system, with the proviso that the performance of the product in a cladding system would be dependent on further testing. And it's worth noting that the certificate itself, on its final page, stresses that it relates only to the product or system named on the front page, and that it has to be read as a whole. Now I come on to deal with the written evidence of Mr. Claude Verler, who described the circumstances in which he provided to the BBA classification report 5A and sought confirmation from them that this information was acceptable for their purposes, to which they responded in the affirmative. He has confirmed in his witness statement that he did not provide the sole incomplete report for the cassette variant because it was a single sample test report, not a valid classification report, and that at the time he considered that the sole cassette test result was a road result on the basis of his understanding at the time that the cassette would perform better than rivet. When considering the spread of flame from an external source to the cladding on the building, The cassette, he thought, may reasonably have been considered to be more resistant to ignition than the riveted version. Mr. Verler has further confirmed in his witness statement that he did not have sufficient knowledge about the UK regulatory regime to understand how the BVA would reach its conclusion on NC0, but he was aware that it would be drafted by the BVA and be reviewed by regulatory authorities and technical assessors. In assessing whether his failure to disclose to the BVA or otherwise the outcome of the 2005 cassette testing represented an intention on his part to hide what he knew to be an adverse result, the inquiry will wish to attach strong weight to the following matters. First, on a proper interpretation of the BVA certificate, the disclosure of such information was immaterial to the scope and purpose of the certificate because the testing related to products with a different surface stroke colour and fabrication. Second, the cassette testing was carried out by the CSTB, which was the principal, if not the only, testing house available in France, and with which not only the company but the BVA and doubtless others had a close working relationship. The CSTB carried out market surveillance on the Merksheim site from 2008 until 2014 on behalf of the BVA, and had direct knowledge of the classifications that the company obtained from time to time. As Ms. Amaro so stated in important oral evidence, the arrangements between the BVA and the CSTB were such that she would have expected the CSTB to disclose to the BVA any adverse testing relating to ACMPE. It's therefore unlikely in the extreme that Mr. Verler could have believed that this information would have remained secret. Thirdly, the outcome of the testing was described by the CSTB as not usable, although it was suggested that the result gave an idea of the behaviour of the product in fire. We submit that given Mr. Verler's general experience, it was not unreasonable for him to consider at the time this result relating to the performance of the cassette fabrication in a particular system to be atypical. It is clear, however, that by 2011 at the latest, Mr. Verler was addressing the 2005 road result relating to the cassette fabrication and was engaging in relation to it with the CSTB. And I go on to stress the following important points, which we detail in much more extensively in our written closing. Mr. Schmidt and Mr. Verler have acknowledged a growing awareness of the risk that ACMPE in general, unless deployed in the context of an appropriate fire risk assessment, could contribute to the spread of fire, and that this awareness led them to take a number of precautionary steps. Those precautionary steps taken by the company included the following. First, arranging to modify references to ACMPE in its marketing so as to eliminate any claim that a panel could achieve ENB, reducing as far as possible the price of ACM-FR. From early in 2014, giving a voluntary instruction to both internal and external staff as to the disclosure of information concerning ACMPE, particularly in cassette fabrication, the 2011 ENB result for rivet still being technically valid until 2016, and encouraging its sales staff to focus their efforts on the sale of ACM-FR. The marketing material at the time of the supply of ACMPE for Grenfell Tower was therefore not misleading, and in any event, there is no evidence that the marketing material was taken into account by the supply chain. If anyone in the supply chain relied on outdated marketing material, that was not something over which the company had any control. Moreover, anyone in the supply chain could have been aware of the existence of and the possibility of utilising a fire retardant product. Those involved had originally specified ZCM, zinc instead of aluminium, FR panels. There are examples of the company specifically providing the Class 0 test report in relation to the FR product, thereby alerting customers not only to the existence of that product, but to its Class 0 fabrication, to its Class 0 certification. No reliance can or should be placed upon the assertions of those in the supply chain who claim to be unaware of the availability of ACM-FR. In circumstances where there was a perceived need to reduce cost, their decision to prefer ACM-PE was probably cost-related. In any event, and this is important, there is certainly no evidence in the case of the Grenfell transaction that anyone on the part of the company pressed or pushed for ACM-PE to be preferred as distinct from ACM-FR. In general, therefore, the evidence shows that customers with whom the issues were discussed were told about the ENE classification result, as well as that result being available on the website of the CSTB. Several of the company's fabricator clients, such as Simco and Taylor Maxwell, were made aware of this information. Unfortunately, it seems this did not apply to CEP, at least not by direct communication on behalf of the company, though the information was just as available to them as it was to others. During the evidence of Deborah French on day 88, counsel to the inquiry expressly acknowledged that information as to the ENE classification was sent on to customers, and it was suggested that Deborah French alone appears to have failed to do this. It's unrealistic, however, to suggest that UK sales representatives should have advised on the UK regulatory regime relating to cladding systems, not least because they would not have the detailed information about other products and systems within which the ACM-PE would be used. They were, however, aware that any relevant technical requests from customers could be sent to the company's technical team for review and would have facilitated this. Now, I want to say a few words, if I may, about the way in which the ACM was used on Grenfell Tower. Of course, the company did provide guidance as to the way in which it might be used. But that information as to the methods of fabrication doesn't seem to have been consulted at all by those involved in the Grenfell Tower refurbishment project. As a result, there were numerous departures from this information, which have been fully detailed by Barbara Lane in her Phase 1 report in April 2018, Section 8. On the tower itself, only 2/3 of the external surface comprised ACM-PE, and of that, at least 50% was comprised of fabric panels fabricated in a fashion which can only be described as wholly unorthodox. And as I've mentioned, an equivalent area of the facade comprised the alley glaze panels and windows. As Mr. Hyatt pointed out, the ACM-PE used on the columns and crown of the tower was fabricated in a way which was peculiar to Grenfell Tower and which could not have been anticipated by the company in a construction project of any kind. In relation to the more orthodox 50%, even that was utilised within the context of an irregular building construction, in that there were numerous departures from regulatory guidance, including matters such as the absence of cavity barriers around the window openings. These deficiencies were not something which the company could have been expected to anticipate. Taking into account the various considerations I set out above, it's clear that no more than a third of the external surface of the tower was clad in ACM panels fabricated in anything resembling an orthodox manner, and of these, an unknown proportion fell away in the early stages of the fire. Many of the ACM panels were fabricated in a way which the company could not possibly have foreseen. Moreover, the ACM panels were utilised throughout in a wholly unorthodox and irregular cladding system for which the company bore no responsibility. That cladding system comprised a very large number of ACM panels in an unorthodox fabrication and a range of other combustible materials such as the alley glazed panels and a whole range of other combustible items, and comprised extra thick insulation, which, as already mentioned, covered the majority of the tower. It's a remarkable feature of the evidence within phase 2 that hardly any of the witnesses were prepared to acknowledge an awareness of the combustible nature of the core of the panel, though some admitted to an awareness that it was plastic, and some but fewer admitted that the core was therefore combustible. The inquiry may take the view that those who profess ignorance of these matters do so with their own interest to protect. Mr. Sekula has emphasised that a responsible specifier would have taken into account the combustible nature of ACMPE when selecting the combination of materials to use on the external facade. He confirmed that a reasonably competent cladding contractor would have known that the various types of insulation used were combustible. He confirmed that a reasonably competent cladding contractor ought to be aware of the combustibility of ACMPE cladding, and he highlighted the fact that a reasonably competent contractor would have checked with the manufacturer or the supplier to confirm whether an FR core should be used. And he said, and we agree, that he would have expected a design and build contractor in relation to Grenfell Tower to have considered the appointment of a facade engineer or consultant. He observed that in relation to design, both Studio E and Harvey had design responsibilities. Moreover, the inquiry may take the view that irrespective of the precise state of knowledge of individual witnesses, there is a more fundamental point. Since no one concerned with the choice or use of the ACMPE could have been unaware of the existence of the core, it would follow that anyone responsible for the choice or the use of it had the option to check the combustibility of the core, whether by asking the manufacturer directly, which the evidence shows to have occurred on other projects, or by some other means, such as looking at test results available on the website of testing and regulatory bodies. And none of those responsible for the refurbishment can escape their share of responsibility by claiming ignorance or lack of information. Finally, we respectfully remind the inquiry that it's already clear that the kind of tragedy which occurred at Grenfell could only have occurred as a result of a unique combination of factors, including the combination and configuration of the materials used in the refurbishment, the failure of compartmentation and other internal systems, and undue reliance on the stay-put policy, among others. We attempted to assist the inquiry as to the interaction between many of these factors in the schedule forming part of our written closing at the conclusion of phase 1. More recent evidence as to the lack of maintenance and fire protection, lack of maintenance of fire protection systems can now be seen to have contributed to smoke spread and inhibited the firefighting ability of the LFB. This extraordinary range of factors, should we submit, be regarded as ultimately responsible for the tragedy to a far greater extent than the role played by any individual product. Accordingly, it's respectfully submitted that the conclusion of the inquiry's phase 1 report that the presence of the ACM rain screen cladding in the external wall was the principal reason why the fire spread so quickly, can now be placed in a far wider, and we respectfully submit, more accurate context. We would add this final observation. It may well be that the inquiry will ultimately conclude that there were significant deficiencies in the regulatory regime before and during the refurbishment of Grenfell Tower. It may well be, furthermore, that the inquiry will conclude that those who carried out refurbishment failed, either properly or at all, to apply that regulatory regime to the construction work which they had agreed to undertake. It would, as we suggest, be wrong and unfair for the inquiry to pin the blame for this tragedy upon the manufacturer of cladding panels which were known to be combustible and which were nonetheless treated by all those concerned as being usable in conformity with the regime. Thank you, sir.
Thank you very much, Mr. Hockman. Mr. Militao, I think you want to...
Yes, Mr. Chairman, thank you. Very briefly on the subject of the FBS, the French blocking statute, I just want to say two things very briefly. First, my learned friend Mr. Hockman, Queen's Counsel, has not quite accurately stated what the inquiry told Arconic solicitors. What was said in correspondence was, and I quote, "Counsel to the inquiry does not intend to refer in any closing statement he may make to the reasons why the Arconic employees did not give evidence," close quote, and no more than that. It was certainly not a reversal from any previously publicly stated position. Second, Mr. Chairman, we, certainly the inquiry team, do not necessarily accept the conclusions of Arconic's proffered French law experts' report. It is right to say only that the question about the application of the French blocking statute to this inquiry is controversial as a matter of French law, and the panel, we hope, will consider that question in due course when reflecting on the evidence as a whole. That's all I wish to say. Thank you.
Thank you very much. Well, it is now 1:15. And Mr. Hockman, thank you for your statement. We are now going to break for some lunch, and we'll resume at 2:15 when we shall hear from Mr. Craig Orr. Good. Thank you very much.